Hello, welcome to the docket presented by Defense Diaries. I'm your host, Bob Mata, and this is our continuing coverage of the Delphi murders. And for those of you who aren't familiar with the case, a quick primer. Back in 2017, February 13th to be exact, two young ladies by the name of Abigail Williams and Liberty German were dropped off at a nature preserve around Delphi, Indiana, around 1:30 in the afternoon by Kelsey German. And the girls went on a walk. They went to go take some pictures for Snapchat and just went to hang out. It's an area where a lot of people go and hang out. And girls are supposed to get picked up at around 3 p.m. By Libby's dad. He got there, had no contact with the girls. He went out, searched for the girls. That continued till about 5:30. The family's calling everybody they know. The girls never show up. No one hears from them. Ultimately, law enforcement is contacted, and they begin a search. Search goes on up until the point that they're no longer able to see. The search ceases at some point, at least the on the ground search. And unfortunately, the following morning, the girls are found on adjoining property to the nature preserve, and the case is investigated for 5 years, and it ends up going cold up until October of 2022, when an arrest is finally made, and a gentleman by the name of Richard Allen is arrested. And from that point forward, we have been plowing towards trial, which is set to go on May 13th of this year. And it has been a mess getting there, which is what a majority of our coverage is, handling the procedural side of this as we try to make our way towards trial. And tonight is no exception. There's been yet another filing in the case that never sleeps. So before we get to that, let me bring in my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hi, all. And before you get started, in the chat, can you send me that site? Because it's not a site in the memo. It's in the motion itself.
We didn't get a memo. It's just the
No,
motion.
I mean, I don't see that case cited in the motion. Is it?
Yeah, it's under the law on page 7, but yeah, I'll send it in private chat.
I see ER. Is that the same thing?
That's it. It's 123 Northeast 3rd, 675. That's the site.
Got it.
All right.
Okay.
Thank you. Okay. So we owe you guys a couple of filings still. The hope was to get to those, and namely that was the state's response to the third request for a Frank's hearing, and then the defense's reply to that. Of course, when they continue to file things, it makes more sense to do the timely thing, and then we'll still go back, because we don't want to give the impression that we're not reading state responses or state filings, because we want to read everything, and we always do. Those just happened to drop when we were out of the country. So we will get back to that. And as I've stated, it is still my intent to have Allison and I, we really want to go through and put that particular motion that was argued in the Idaho 4 case, in the Brian Koberger case regarding the survey. We want that done, and we want that up in comparison to what's going on in this case, because there's a lot of interesting issues, and I found it to be a fascinating hearing in a lot of different ways. And moreover, it really was something that kind of piqued my interest, in the sense that Ann Taylor was echoing a lot of what I say about pretrial publicity and probable cause affidavits, and how those are typically the only thing that we see floating around in public in a vast majority of cases. I would say all cases up until recently, in which 2 cases, which is this case, Delphi, where the state had their PCA come out, and which was broadcast all over the world once it was made public and unsealed. And then we have the Karen Reed case, where that PCA came out, or that actually wasn't even a PCA. She was indicted by a grand jury. And in both those cases, the thing that does not happen and has not happened in the past is both defense teams put their theory of the defense out to the public so that that can be out there floating along with the state's theory of the case. So in the two cases where I've seen, maybe in my whole life, where the defense and the prosecution both have their theories floating, those two cases just so happen to have the most toxic communities that I've ever seen anywhere. And I don't think that's a coincidence. I think that a lot of people were put off by the fact the defense was able to get their theory of the case out to kind of try to even the scales of justice. And I think people have taken exception to it. And for those people, I say to you, tough shit. You know, that's the way it should be. It should be equal. Both sides should have their argument. If the state's going to put out their theory, the defense should have their theory out there too. If the defense has a theory, there's plenty of cases where the defense does not have a theory. In these two particular cases, there happens to be theories of defense that are beyond just relying on the state not being able to meet its burden. They both cases actually have an alternate theory of what happened. So there's that. So we do plan on forward with that live. So I think without further ado, I think what we should do is probably just jump into the document, which,
And if anyone's
Or-
wondering out there while he's pulling that up, why I might be making faces on camera, I'm not sure, but it was just things like literally I was reading part of that motion again, and so those faces were for that, not for anything Bob was saying. If I even
Oh.
was making them.
Okay. Oh, great. Perfect. So my Acrobat just closed down.
I can do
Let
it.
me see if can you I should be able to
Want
pull
me to
this
share
up.
it? Okay. And
I
I'm
don't know
just
why
gonna
it's having
say this while you're looking for it, okay? So I pulled up the case that's cited in here. Bob and I had talked about it. We were reading from it earlier, and one of the first, sometimes you always want to cite the state constitution in addition to the federal constitution whenever you're asserting a violation. It's just the way you do it, especially because I've seen some parts of the Illinois Constitution that's has recognized an expanded version. And one of the first sort of head notes in this case was the case that they cited was that at the trial level, the defendant in that case failed to make any specific reference to the state constitution. And as such, he waived any argument in that regard. So I kind of went back to see, I didn't see them even cite the state constitution. And they didn't, nor did they actually cite the federal constitution. But anyway, so that was probably why I was rolling my eyes.
Okay. All right. So let me open this up. I don't know why it had logged me out of my particular. It's weird. Okay. I don't know what the hell. I had it all set up. God, I hate tech shit when I'm live. It's the worst. Let me try to get this thing up. Okay. Yeah, I don't. All right, can you pull it up? I don't know what's going on with my Acrobat. It's
Okay.
weird. Yeah.
All right. I'm coming at you here.
Am I going to be able to scroll through it?
I'll do it.
Okay.
Because I don't think so, because I can't scroll through it when you're doing it.
Okay.
Huh, I forget where I did this one
Sorry, guys.
before.
I don't know, like, what the hell is going on here. It's like somebody hacked me, which is, of course, very paranoid. Like the thing on my second screen, like I can't even get it to.
So, I am trying to remember what I clicked on to do this.
To
Uh,
what? Share screen?
yeah. Is there something at the bottom? I'm not all the way down there.
Yeah,
Oh,
it's
yeah, there it is.
present.
Okay. Yeah,
Present.
yeah, yeah. My mouse was down to share
Okay.
screen. Okay. Uh,
Yeah, the sooner that I have my mods being able to do this stuff for me, the better. Hint, hint. Because this is not my jam. Like, I don't know. Can you pull it up
yeah,
or no? Just go to present, share screen, and then whatever screen you have it on, pull it up. Okay. Mm, okay. Mm. Like, I don't get what's going on. Like the same thing I do every time. All right. Okay. Well, while she's trying to figure that out, and I'm trying to figure this out, you guys are just gonna have to hang tight. I had the doc ready to go, and then all of a sudden, when I went live, my Acropat shut down, which is, and now it's like clicking, and I can't pull it off my second screen. All right. Here's the alternate thing I can do. I can look at sent mail. All right. Huh. Wow, it's so weird. Uh, mm. Did you get it up? Are you having a hard time getting it up?
I'm trying. I might have to it looks like I need to do something to unlock the screen. Hold on, by selecting lock at the bottom left corner.
Like it seems like it has something to do with the Acrobat. Um, like I'm trying to open it up, but it's like it's not
I gotta
opening
quit and
my.
reopen, it should work.
It's a what happened is it like logged me out of Acrobat, and I can't. I don't know. Sorry, guys. Not the start we wanted. Obviously.
There we go.
Okay.
Now it's working. Okay.
For whom? For you?
Can't see it?
Yeah, I think, but I want to be able to control it. Like, can you just send me your login for Acrobat? Like, I don't like I'm not logged in.
Yeah, I'll text it in this message it.
Yeah, just message it to me because that'll solve the issue. Like for some reason I logged out and I must be putting in the wrong intel for
shit. Actually, I got to do it from my phone.
No, it's too hard when I'm reading for her to scroll at the same time that I'm reading. It's way easier for me to do it. It's not a matter of her controlling or me controlling. It's just.
By the way, Bob, I emailed you the document directly, so you shouldn't have this problem with that with my email.
I didn't see your email.
I can't hear you.
I sent it to you. When did you send it to me?
And then I scanned it, fixed it, sent it back to you in a different format.
Oh. Okay. Yeah, I'm not. Oh, yeah, I just said that. Okay. Yeah, but then I have to sign into Genius Scan. Just
no, you don't. It's at the bottom of the document. Just open it. It's at the bottom. Don't click the link. Go to the bottom of the the email.
Okay.
And I just sent you the password and text.
Okay. Yeah, that's the easiest thing for me to do. All right.
It's literally in a document at the bottom of the email, though. Not a link.
Okay.
The actual.
All right. Okay. It's still asking me to sign in to Adobe. So, like, that's what I need to do. What email address are you using for it? Your normal one?
I put it in the private info.
Can you text it to me?
I did.
Why are you yelling at me, dude? Like I'm like with a million people watching. I'm just trying to get this logged on, dude.
Your daughter is over here trying to get I was getting irritated. She keeps saying something.
Okay, well, don't take it on to me. It would be easier if you were talking to the people while I was getting this done. Like
all right. Well, you want me to remove this? Stop sharing my
Uh-huh.
screen in the meantime?
Yeah, because I'm going to get this thing done.
Okay, guys. Hi. So I'm sure that was fun. But so anyway, like I was saying with regard to this, motion. I mean, when Bob got to the end of it, he was like, I don't understand what statements they're actually looking to suppress. I don't think they included the actual content of the statements, but what we can assume from the fact that the state has never mentioned that there was any sort of confession before, that it's not really a confession, but that there's certain information. It could be, what time he got to the bridge or something else that he did. Any of the information or things that he said that they just want to have excluded so that it's, not there. Maybe it was like, yes, I was on the bridge at exactly that precise time, which, so it could be something like that they just don't want to make it any easier for the state to prove their case. So I don't know which case law nurse asked me about here. But there's been
you've got too many things signed up to it. Just pull it up and follow along with me.
Okay.
That's fine. Just you pull it up and you'll just have to follow along while I'm reading. Yeah, because I can't even control it. It's so weird. Okay. And make it bigger.
Scroll it.
That's what I'm saying. Yeah.
I got it. Is that good?
All right. So I mean, as good as it's going to get for me, I guess. All right. So this is, as you guys know, we covered the last motion to suppress, which was relating to confessions that were made um, by Alan while he was in Westville, and they're seeking to have at least what appears to me a portion of those confessions suppressed. And now we're different. This is a different statement that they're trying to suppress, and this is where he's not in prison. This is prior to him being arrested, and these are more your typical suppression motions that you'll see. So, all right, are you ready? Because I'm going to start reading, so you got to kind of scroll along with me. Okay, comes now the accused Richard Allen by and through counsel and moves this court to suppress all statements from his October 26, 2022 interrogation at the hands of law enforcement Jerry Holman, who failed to read Rick Allen his Miranda rights while yelling and swearing at Rick Allen, lying to Rick Allen, and attempting to intimidate Rick Allen behind a closed door in a tiny interrogation room at the Lafayette Police Post. Additionally, a key portion of the videotaped interrogation provided to the defense is missing. The missing portion of that video is the beginning of the interrogation when Miranda should have been read. In support of said motion, the accused states the following. First interrogation. Law enforcement officers requested Rick Allen to appear at the Delphi police station to answer questions on October 13th of 2022. Allen voluntarily went to the station and sat down with the police, thinking that he was assisting them in solving the Delphi murders, since he had been on the trails earlier on the day that the victims disappeared. Rick wanted to help out any way he could, and that is clear in the video. This video was previously provided to the court on September 18th, 2023. The October 26, 2017 interview is being sent to the court overnight via certified mail for the court's review. Paragraph 2, the two officers that interviewed Rick Allen on that day were Tony Liggett and Steve Mullen. Paragraph 3, Rick was read his Miranda rights and signed an advisement of rights form, which is normal protocol for law enforcement before an interrogation begins. Paragraph 4, for the first roughly 3/4 of the interview, it is apparent from the interview, Rick believed that he was assisting the police in their investigation and search for those that murdered the victims in the Delphi case. Paragraph 5, however, eventually, when it became obvious that Liggett and Mullen were actually pointing the finger at Rick Allen as the killer, at one point in the interview, Rick says, quote, I don't want to be somebody's fall guy, and we're going to try to make pieces of a puzzle fit somewhere. They don't fit, so we can close this thing. I'm not saying you guys, please don't think I'm questioning your integrity. That's not what I'm saying, end quote. Paragraph, all right, like when I'm actually reading, though, can you not move it?
I
Like it's
thought it was
really hard.
perfect timing, sorry.
No, like just let me finish a paragraph and then move it up. It's like it's hard for my eyes to move. Yeah, this is not optimal. Oh my God, somebody said, Bobby, don't sash your woman. Okay, just can't win. Can't win with this thing, man. However, when the Liggett and Mullen amped up the intensity of their questioning, even positioning their bodies closer to Rick said the following. It's over. I was perfectly fine. I was cooperating. I was going to give you my phone. And then, when you started reading all these documents, that's it. Here's my thing is I feel like you guys think I done this. So I'm done. You do what you need to do. It's your job. I understand that, but you better fucking leave my reputation out of it. So you do what you need to do. And then, like I said, when you find this guy, I'll expect the apology, end quote. Rick then described how police were trying to ruin his reputation by accusing him of the murders in public, even groping him as they patted him down in the street. Rick was expressing that the mere act of mentioning his name as a possible killer or patting him down on the public street as if he were a criminal would ruin his reputation was greatly upsetting. Paragraph 7, Liggett and Mullen did read Rick Allen his Miranda rights before they began their interrogation. And additionally, Rick Allen was aware that he had freedom of movement as Rick, ultimately stood up and walked out of the interrogation room. All right, babe.
I thought you could see 8, sorry.
However, at the end of the interview, parenthetical, that turned into an aggressive interrogation, Rick made it clear that he no longer wanted to talk to law enforcement. Paragraph 9, within hours of the first interrogation, Liggett drafted an affidavit for search warrant. Judge Diener then signed the warrant to search Rick's home and vehicle. On that day, Rick Allen's vehicle was also seized. So this is on the 13th of October. Okay, so it's 13 days before he ends up being arrested. Paragraph 10, the defense will not, underscore, be seeking the first interrogation to be suppressed. Second interrogation. On October 13th, 2022, Kathy Allen, Rick's wife, and Rick Allen asked the state police when they could pick up their vehicle that had been seized. They were told that they could pick it up in a couple of days. On October 17th, 2022, either Kathy or Rick contacted the state police to determine how and when they could get their vehicle back that had been seized, as they were in need of that vehicle, as Kathy and Rick were having difficulty sharing only one vehicle as they worked in two different places and needed two vehicles. 13, after a few phone calls with state police, finally on October 26th, Rick and Kathy were scheduled to arrive at the state police post in West Lafayette at 9 a.m. to pick up their vehicle. 14, on October 26, 2022, Rick Allen drove with Kathy to the West Lafayette police post to retrieve their vehicle that had been seized. Allie, you've got, like, you
Yes.
have to pay attention here
I
when
know, I was
I'm
actually gonna
reading.
ask if one of the girls could take this over because I'm trying to research something. This is kinda sucky, but alright. Sorry.
Yeah, I know, it's awful. That's why I was trying to log into my that's what I was trying to explain. This is not optimal. And I can't see, like, the bottom of 12. You gotta
Oh,
scroll it down a little bit. Oh, no, I actually read it. Okay, so 13, after a few phone calls with state police, finally on October 26th, Rick and Kathy were scheduled to arrive at the police post in West Lafayette at 9 a.m. to pick up their vehicles. On 14, on October 26, 2022, Rick Allen drove with Kathy to the West Lafayette post to retrieve their vehicle that had been seized 13 days earlier by law enforcement. 15, state police had told Rick and Kathy that upon arrival, their car would be released, but never mentioned anything about additional questioning. 16, when Rick and Kathy arrived at the station, Holman met them at the front and said that he had just a few things that he wanted to clear up before he released the vehicle. Holman requested Rick to follow him to the interrogation room without Kathy. Rick complied. 17, Kathy was not allowed to participate in the questioning. She was told she could wait in the lobby. 18, Rick arrived with Holman in the interview room. 19, however, for unknown reasons, the video provided to the defense is missing the beginning portion of the interview when procedural matters are typically handled by law enforcement, such as the reading of Miranda, advisement of rights, and confirming with the suspect that he is free to leave, if in fact the suspect is free to leave. 20, in this case, either A, the camera was only turned on after Holman and Rick were already minutes into the interview, because the video provided to the defense does not show Holman and Rick entering the room, sitting down, and beginning the interrogation, or B, the camera was recording the entire time, but the beginning of the interview was later edited out before being turned over to the defense in February of 2024. 21, in italics for emphasis. Either way, the beginning of the interaction between Holman and Rick in the interrogation room was when introductions are typically made and Miranda rights are already reviewed, is missing. In the 70 plus years of experience between co-counsels, this is highly unusual, especially on a high profile case of this nature. 22, the defense had not been provided with any report explaining this missing part of the video. 23, to make matters more suspicious, Holman claims in his November 1st, 2022 report, memorializing his October 26 interrogation of Rick Allen, the following, quote, I asked Mr. Allen if he remembered the other detectives reading him his Miranda rights, and he said yes. I told him that he was free to go at any time and that the door was unlocked, end quote. 24, Holman's report doesn't identify who the other investigators are that purportedly reviewed Miranda with Rick. Now, let me ask you, does that warning, in your estimation, that would have been 13 days prior, does that stick? Like, if he's read
My
his Miranda
instinct was
rights?
no, but just to let you know, that's what I was double checking and researching. I would think that there could be multiple arguments. One, that first one doesn't sound like it was as custodial. So Miranda warnings during a non-custodial event to carry over to another. I highly doubt there's any. I feel confident in saying that it would not carry over, but that's literally what I was trying to pull up some actual law on while I have to scroll this thing.
I mean, it's interesting in the sense that there they actually pulled out the typical Miranda, the notice of rights in the waiver form and had him sign it. Like, why wouldn't Holman just do that again just to be
Well,
safe?
that's why I'm saying, and I don't know if him saying, "Do you remember your Miranda rights?" and him saying, "Well, yes, I do." I mean, that's a different scenario than just having given it to him on that occasion prior and then just didn't do it. That's actually what I was trying to research, of like reference without actually reading it, trying to kind of go more in depth with it. But
Yeah, well, that's why I wanted you to pull up the case they cite, which
well,
is
I do have that case up.
Ruiz. No, I know, just not for now, but for the discussion after.
Yeah.
Okay.
Can't I email this to somebody and then they can take
I don't
over this
know. Let's
scrolling thing?
let's just struggle through it and get through it. It's not going to take me that long.
I know, but then I won't be ready to do the next part. But go ahead. Let's go.
That's okay. All right. So Holman's report again doesn't identify who the other investigators that purportedly reviewed Miranda with Rick. 25. Holman's report doesn't detail when, where, or how these purported investigators purportedly reviewed Miranda with Rick. 26. Holman's words quoted in paragraph 23 above appear nowhere on video. In other words, Holman is not shown asking Rick about his rights, nor is Holman viewed telling Rick that he is free to leave. '27. In his report, Holman indicates that these words were stated to Rick Allen at the very beginning of the interview. The beginning of the interview is missing. The defense was diligently searched through the discovery for the Miranda waiver of rights form signed by Rick Allen on October 26th, 2022, and the defense has found none. 29. The defense has diligently searched through the discovery for any reports by the state troopers who were on duty that day, such as Jay Harper and David Vito, who would have potentially read Rick his Miranda rights on October 26, 2022. The defense has found no such reports. 30. Justice Brad Holder's February 17th, 2017 interview is missing, just as the mimicked crime scene found on Holder's social media page is missing and still has not been turned over to the defense, but the defense thankfully located in Georgia. And just as Rick's original tape statement to Dan Doolin in front of a grocery store in February 2017 is missing, the beginning portion of Holman's interview with Rick Allen is also missing. That Dan Doolin thing is the one that really bugs me the most. Like that's like his, that's where he makes his voluntary statement, or what people call him admitting that he was on the bridge. Like that's such a huge statement. For that thing to be like vanished is bizarre and unsettling. Like that more than anything else bugs me. That the Dan Doolin thing from the original statement has vanished off the face of the earth is to me the most damaging in the eyes of my perception of law enforcement, to be honest with you. Okay, 32. Therefore, at this time, it appears the defense that Jerry Holman's claims in his report that Rick Allen was asked about his Miranda rights and told that he was free to leave are false, and that the key video evidence that would prove as much is missing. 33. The following are true and accurate depictions of what occurred on Allen's October 26, 2022 interrogation, as shown on the videotape of said interrogation that was not missing or deleted, but was actually provided to the defense. A, on video, Holman never read Rick Allen his Miranda rights, nor mentioned them to Rick Allen. B, Rick Allen was placed in a tiny confined room without windows. C, Rick Allen was placed in a tiny confined room and Holman shut the door. D, Rick Allen was placed in a tiny confined room with Jerry Holman while the door was shut. Okay, E, a considerable size difference existed between Rick Allen and Jerry Holman. F, a power differential existed as Holman was a state trooper in his home court, Lafayette Police Post, while Rick Allen was a CVS worker from Delphi who had only driven to West Lafayette to pick up a vehicle he and his wife needed for transportation. G, Rick Allen was never told that he was being videotaped. H, when Jerry Holman would leave the room, he told Rick Allen to sit tight at the 9:25 and 45:20 marks or to hang on one more second. And that's at the 1640 mark. In other words, Jerry Holman told Rick Allen that he could not leave. And we're going to go through the Ruiz case that they cite here just to give you guys an idea of why he's bringing these things up, because like both Alice and I, when we read this next section, which is coming up, we're like, why is he like highlighting the fact that, you know, that they lied? Because the Supreme Court is flat out said cops can lie in interrogations. You know, I mean, they're allowed to do it. And so we'll explain it as we go. Jerry Holman lied to Rick Allen during the interrogation several times, including the following. At the 7:10 mark, Jerry Holman told Rick Allen that, quote, "We have experts that say that's you on the bridge and that's your voice on the video," end quote. There is no evidence that supports this statement. Jerry Holman lied to Rick Allen. At the 15:25 mark, Holman told Rick Allen that, quote, "The experts are saying that's you on the video," end quote, and that, quote, "experts are saying that you said, quote, down the hill," end quote. There is no evidence supports this statement. Jerry Holman lied to Rick Allen. 3, or III, Roman numeral 3, kind of. At the 15:07 mark, Holman tells Rick that witnesses saw, babe, I need a scroll. I'm at the top of 3 there.
Oh, sorry.
At the 15:07 mark, Holman tells Rick that witnesses saw a gun in his pocket. There is no evidence that anyone claims to have seen a gun in Rick's pocket. Holman lied to Rick Allen. Roman numeral 4, at the 39:05 mark, Holman states, "I'm not lying to you about anything. Everything I'm telling you is fact. The experts say that you said go down the hill." Holman was lying to Rick about many things, and not everything Holman told Rick was a fact. Roman numeral 5, at the 42:33 mark, Holman said, "I'm not lying to you, Rick. That's unethical." Holman had been lying to Rick. K, Jerry Holman told Rick Allen in what was supposed to be an exploratory interview, quote, "The prosecutor and the other investigators, they want to see you lock you up and throw away the key," end quote. L, Jerry Holman barked at Rick Allen in what was supposed to be an exploratory interview. "If you don't tell me, you're going down for this," end quote. Jerry Holman told Rick Allen it was supposed to be an exploratory interview. "Do you realize the death penalty is on the table for this?" End quote. N, at various times, Jerry Holman yelled at Rick Allen, including using profanity-laced language while accusing Rick Allen of the murders. Rick Allen asked Holman to stop the interview. Rick said, quote, "I'm done," early in the interrogation at the 12:05 mark, but Holman continued his interrogation. P, the state police never turned over the vehicle to Kathy Allen, and Rick Allen was arrested. Returning the vehicle to Rick and Kathy was merely a subterfuge to get Rick to the police post to be interrogated. The law, paragraph 34, the Indiana Supreme Court dealt with a very similar fact pattern in State v. ER, which I believe is last name is Ruiz. The site is 123 Northeast 3rd, 675, which reversed the Indiana Appellate Court, holding that Ruiz's constitutional rights had been violated and therefore suppressing his statements. In State v. ER, the accused had voluntarily driven to the police station at the request of the police to answer questions concerning an allegation of inappropriate touching. in bold. And in this case, Allen voluntarily arrived at the station to pick up a vehicle, but unlike ER, Allen was unaware that he would be asked questions once he arrived at the Lafayette police post. 36. The following occurred when ER was interrogated, compared to when Rick Allen was interrogated. A. ER was interrogated in a small windowless room. Rick Allen was interrogated in a small windowless room. B. Law enforcement officers failed to provide Miranda warnings to ER. Videos show that Holman failed to provide Rick Allen with his Miranda warnings. C. Multiple times law enforcement told ER to sit tight. On multiple occasions, Holman told Rick Allen to sit tight when he would leave the interrogation room. D. In ER's interrogation, law enforcement actually told ER that he, ER, was able to walk out of the interrogation room door if he wanted. ER was also told that he did not have to talk, he did not even have to talk to law enforcement if he didn't want to. Still, the Indiana Supreme Court found that even with those particular statements by law enforcement to ER was not enough cause to cause ER to feel free to leave. Contrast ER's interrogation with Rick Allen's interrogation. On video, Jerry Holman never told Rick Allen that he was free to leave, nor did Jerry Holman ever tell Rick Allen that he did not have to talk to law enforcement. E. In ER in Ruiz, the police significantly undercut any initial message of freedom when they dramatically changed the interrogation atmosphere, end quote, when a second officer entered the room and became more aggressive. Here, although there was only one officer involved, Holman, that officer started the interrogation in a much calmer manner before amping up the intensity, ultimately erupting with cursing and yelling at Rick Allen. F. The officers did not tell ER that he wasn't under arrest. Holman never told Rick Allen never told Rick Allen that he wasn't under arrest. In fact, when Rick Allen continually denied having anything to do with the murders, as well as words to the effect that Holman had made up his mind, so go ahead and, quote, arrest me, Holman never told Rick, you are not under arrest, end quote. G. Police never told ER that ER could end the interrogation at any time. Holman never told Rick Allen that he could end the interrogation at any time. H. The officers repeatedly told ER to explain what happened, coaxing him to, quote, tell us now that we know that you're being, tell us now so that we know that you're being honest with us and not lying. Holman repeatedly told Allen to explain what happened and attempted to coax Rick Allen to talk to him for a variety of reasons. In ER, in Ruiz, I wish he'd just call it Ruiz. The officers were explicit that they believed Ruiz engaged in the accused conduct, and their questions were accusatory, not exploratory. Throughout the interrogation, Holman explicitly told Rick Allen that he, Holman, the prosecutor, and the other law enforcement officers all believed that Rick Allen had engaged in the accused conduct, parentheticals, murder, and that Holman's questions throughout the entire interrogation were accusatory, not exploratory. Included in the videotape interrogations are the following exchanges that highlight the accusatory, not exploratory nature of Holman's interrogation of Rick Allen. Jerry Holman, you're going to drag your fucking wife and your daughter through this because you're too fucking bullheaded to get out in front of this and admit you made a mistake. And whatever the fuck happened out there, we'll never fucking know because you're too big of a fucking inaudible. All right. Jerry Holman, the evidence clearly indicates you're involved in this. Rick Allen, no. Jerry Holman, it fucking does. Just quit looking down. This is going to go quick. Rick Allen, it doesn't. I'm telling you that there's no way that a bullet from my gun was used in these murders. Jerry Holman, and I'm telling you that we had this fucking round on February 14th, 2017, and it's been secured in a fucking laboratory, and we've tested other guns. Rick Allen, you could have taken it from somewhere else then, because it's not possible. Jerry Holman, I did not take it from somewhere else. It was logged in. It was taken. It was photographed. You think we were fucking took around and threw it down by the dead girl's foot? This ain't fucking TV. This is realistic. Rick Allen, I'm telling you, I can't explain something and I'm telling you that fucking analyst, and I'm telling you that fucking analysts explain it. You can't get past this. Jerry Holman, I'm not on video. Rick Allen, neither am I. Jerry Holman, 4 or 5 witnesses didn't see me out there. Rick, me either. Jerry Holman, my round out of my gun wasn't 6 inches away from a dead girl. Rick, mine neither. Jerry Holman, I don't think you're a bad person. Rick, what kind of good person kills 2 people? Rick Allen, you're going to pay for what you done to my wife. You want to fuck with me? Fuck with me. But you leave my wife out of this. Fuck, leave me out of this. No, you're involved in this. Your fucking round is there, Rick. Rick Allen, no, it's not. Jerry Holman, you're guilty of something. You're guilty, and I know it, and I'm going to fucking prove it. Jay, so police questioning of ER was prolonged, lasting almost an hour. The questioning was sustained and relatively drawn out, especially compared to roadside traffic stop questioning, which is like a Terry stop. Holman's questioning of Rick Allen was nearly 3 times longer than law enforcement questioned Ruiz. Holman's prolonged questioning lasted 2 hours and 41 minutes. Of course, that represents the length of the questioning that was actually videotaped. Since there is missing videotape, the entire length of the questioning is unknown. The questioning was sustained and drawn out over that time, especially when compared to roadside traffic stop questioning. K. The officers continued the interrogation of Ruiz past the time that he was supposed to pick up his daughter. Here, Rick went to the station to pick up his vehicle, but Holman never mentioned anything about where or how Rick or his wife were to pick up the car. L. At the conclusion of the interrogation, Ruiz was allowed to leave and return home. This fact is mentioned in the Court of Appeals opinion, but not the Supreme Court opinion. You went up a little too far, Bay.
No, that was it.
Oh, okay. Sorry. Rick Allen was not free to leave as he was handcuffed and arrested on camera after over 2 hours and 40 minutes of denying involvement in the murders. 37. The facts involving Holman's handling of Rick Allen's interrogation are more egregious than those facts in ER in several ways. 38. For example, the Indiana Supreme Court found that Ruiz's constitutional rights had been violated even when Ruiz had been allowed to leave the police station, while in the case at hand, Holman knew the entire time that he was interrogating Rick Allen that at the end of the interview, he would be arresting Rick Allen, as Allen did not make any statements to Holman that were not already known. The entire interview was Holman's accusing and Rick denying. 39, law enforcement clearly knew ahead of Rick Allen's interrogation that they would be arresting Allen for the murders. However, rather than arrest Rick Allen at his home or work after pulling him over, Holman waited until he had one more opportunity to interrogate Rick Allen without Miranda. 40, Holman knew that Rick had walked out of the October 13, 2022 interrogation with Mullen and Liggett, and therefore it was unlikely that Rick would answer any more questions with Holman unless Rick felt that he was not allowed to leave. Miranda would be a nuisance that would likely cause Rick to walk out on Holman the way that Rick walked out on Liggett and Mullen. If so, Holman would not be able to secure a confession that Holman, clearly wanted to secure on his own. 41, according to Ruiz, a defendant is required to show by a preponderance of the evidence that he was subjected to a custodial interrogation. And we'll explain the difference between a custodial interrogation and a non-custodial interrogation. 42, the videotape interrogation of Rick Allen shows by a preponderance of the evidence that Rick Allen was subjected to a custodial interrogation. 43, additionally, the defendant is required to allege custodial interrogation in the absence of Miranda warnings. 44, the videotaped interrogation of Rick Allen shows that Holman did not provide Rick Allen with Miranda warnings and then subjected Rick Allen to a custodial interrogation. 45, furthermore, ER is required to point to, quote, some evidence that his statements were made in violation of his constitutional rights, end quote. 46, the videotape statement of Rick Allen provides a whole host of evidence, as detailed herein, that statements made by Rick Allen on the day in question violated both his state and federal constitutional rights against self-incrimination. Wherefore, the accused Rick Allen requests this court to suppress all statements made by Rick Allen at his October 26, 2022 interrogation, and to issue a finding that Jerry Holman and the state police violated Rick Allen's constitutional rights. So there it is.
All right.
So
do you want to start with the custodial interrogations?
First impressions.
There's just a lot of things that I find, somewhat lacking as far as, because it seems to me, which is unusual from what we see in our practice, even in other states, that the judge doesn't have to give them hearing. So if they don't cite all the law, and I mean, it's clear they're talking about the Fifth Amendment. They said this under the state and federal, but for all of you out there are so many occasions where the appellate court, form over substance is like literally everything in the law. So there's many times where they're like, well, they just cited, for example, the federal constitution and never made any real argument under the federal constitution or analysis with law interpreting, the application of the Fifth Amendment to this type of scenario, things like that. But they did have that one case. That one case did cover factually a lot, and it covered all the circumstances that are applicable to the court in determining whether something is custodial or is not custodial. So being in custody, it's basically that a person does not feel free to leave. So they covered things like, even if you agree that the officer said you're free to leave at any time, they didn't treat him like he was free to leave. And he didn't feel free to leave. He was left in a room, told to sit tight. They're yelling at him. They're being accusatory. And then that's sort of like what Bob brought up about the lying, how I was like, why are they mentioning that he lied? Well, because in the case that they cited, they took that into consideration when evaluating whether or not the person is in custody for the purposes of Miranda. Now, when you drive to the police station yourself, that's the first huge thing for the state or the government, as far as you're not in custody. You weren't brought there by them. You drove there on your own accord. So that's a big way that they like to get people in. Anytime I've got a client or even a person who calls and I might need a lawyer and the cops want me to go pick something up, absolutely not. Tell them your wife's coming, your sister, your cousin, if you have to go, do not leave the main area. Sign for whatever it is and get out. Don't answer any questions. Don't go anywhere. Don't do anything, because they want you to drive yourself so they can make the argument that you were not in custody. You were not required to be given Miranda warnings.
Yeah, look, here's so, kind of the warts I saw on the last one was I didn't know why they didn't include, or whether or not they were including all of the confessions, right? It's like generically he states it, and Brad wrote the last one, Andy wrote this one, and you can tell they're writing. Like if you've read enough of their pleadings, you can tell which one's writing. And Andy writes more from a place of emotion. Kind of go to going to your form over substance. Like Andy's pleadings lack some substance being case law, which you'd like to see. Like I agree. I mean, I went and I read Ruiz after this, and it's pretty on point. It does a nice job in terms of breaking down, the two things that you need to trigger a Miranda warning in order to get to the point where you can determine that it's a custodial interrogation, right? So, like, just for example, give an example, Allie. Like, say, for instance, you get pulled over, right? You get pulled over, they pull you out of your car, they call that a Terry stop. They're allowed, pursuant to Terry v. Ohio, to do a pat down of your person. Okay. But that's for officer safety.
Right. If there's like an actual reason.
Right.
Uh,
Well, they're
um,
always going to say that, I mean, it's
right.
kind of like
Uh,
the burnt smell of marijuana thing that's going on now.
right. So, and when you do like a traffic stop type of thing, because as you can expect, that happens all the time. So they have sort of separate, you know, application of the Fourth Amendment and of seizure for that purposes that, people get pulled over all the time. It's expected on the road. It's a minor inconvenience, blah, blah, blah. So they look at a couple things. For example, do they extend the length of the stop beyond what is necessary? Did they give you back your driver's license or didn't they? Sometimes that can be a factor. Like, well, they wrote me my ticket. All this time had gone by. I couldn't leave. They still had my driver's license. Well, other times applications are like, well, the stop wasn't over because you know what? The person didn't have back their driver's license. Um, and to tell you right now which under which scenario they can use the license not being back to say this stop wasn't over, or they can use the license not going back to be that you were clearly weren't free to leave because you didn't have your license back. Um, it just kind of goes to show, depending on the temperature and the mood, how something can change. But they also look at the number of officers there. Obviously, if they pulled a weapon, those kind of things, and the length of the stay. If somebody's like, well, I got pulled over and then they brought a dog, my first question is, how long were you waiting until the dog was there? Because if it was a couple of minutes while they were still doing the background and writing out their ticket and doing all of that, well, oh, well, too bad. It didn't extend the life of the stop. It didn't convert it into a different reason. They weren't done with the initial purpose of the stop. Now, as far as lying, as a human being and as a lawyer, I believe that it can be fine for the police to lie. It is an interrogation method, because if you convince somebody that you know more than maybe they're going to admit something. But there's different kinds of lying. Like, for example, you can't lie that um like, I had a client who was like, "Well, they asked me for my phone and they said they had to search for child pornography, so I gave it to them." Well, of course, he wasn't worried remotely that they're gonna find child pornography on his phone, so he allowed them to search his phone. Well, that type of consent is invalid because you lied about literally the nature of what you were going to look for, and in theory, you should have been limited to, uh, to searching for child pornography. Or if they say, "We need to search for X, Y, and Z," and they lie to get your consent on a piece of paper. Well, your the scope of your consent is limited to what you lied to them about. So there's things like that, if they lie about that, that's different than if they say, "Well, we have a witness who says they saw you there," because the law assumes if you weren't there, you're gonna respond like Rick Allen did. Well, that's not freaking possible because there's no way in hell. That's why he's assuming they put it there. Someone put it there because at least the way he's saying it, true or not, is sure as hell could be. It's literally impossible to have come from, for something in my house to have been involved in that murder scene. But then there's situations where the police do the same thing to get a false statement from somebody else, where they tell a witness, and that they can't do. You can't lie to a witness to get them to influence them on their statement, or to hope that they select somebody from a lineup that they might have been unsure about a moment before. It's like, well, so everybody says it was this person. We know it was this person. We just need you to give us this statement, so we're sure to put the bad guy away. And then somebody who may not have been sure becomes sure and gives the statement that the police want. I mean, that kind of lie, you know, would not be acceptable, but that kind of lie is also not a right of the defendants. It would just have to be like a due process argument, or a, you know, fair trial argument. And it would kind of all depend on what maybe the person said afterwards.
Yeah, and I mean, kind of when you're reading through, it's a little confusing to me in the sense that, you know, Andy makes it clear. Baldwin says, look, we're not trying to suppress his statement on the 13th, which was a denial that he had any involvement.
Well,
And
they're also admitting he was provided his Miranda warnings on that day.
right, right. But what I'm saying with respect to the second interrogation, it's all denials, at least that he puts in there. But then he states that the entirety of the interview, the whole 2 hours and whatever, is all accusations and denials. I love you. Sweet dreams. Give me a kiss.
Right, and again, it could be something Night Scout, it could be something kind of, uh, like I said, they just don't wanna make the job any easier, even if he was like, "Well, yeah, I mean, I was on the bridge and, I saw this person, I saw these 2 girls, I saw this, I saw that," they don't wanna have him saying all of that to get in. You guys prove it with these witnesses who describe different people and at different times, and, so I could see absolutely wanting that to be, excluded, which if they get that excluded, and again, we've got no idea, and I know, Bob, you were telling me when we talked about this, you'd probably never put him on the stand, but you're sure as shit he's not gonna get on the stand because then whatever they worked so hard to get out, you know, could be fair game.
Well, I mean, are you assuming that there is something that he said that they want to keep excluded?
Well, yeah, like I'm saying, I think it could be something as simple as, when I was on the bridge, I saw 3 girls, I saw this, it was this time, it was that time, like, why make the job any easier for them? Let them prove he was on the bridge, absent his words.
Well,
Although
I mean,
they're always gonna have that very first one,
well,
but
they
it's
do and they don't. Like that's what I was telling you. The thing that out of all the lost things relating to Rick Allen, the thing that bugs me the most is that they don't have any proof whatsoever of what Allen said to Doolin on the first time that he spoke to him. And there exists this discrepancy in terms of timelines as to, Rick Allen allegedly said one thing to Doolin back in 2017 and then changes his time now,
I personally
and
think what was said in 2017 was I was on there sometime around to me, it's not I never thought that it should be interpreted to mean I was there from 1:30 till 3 o'clock, as opposed to somewhere between 1:30, 3 o'clock.
yeah, and I don't know. It's like, do they not have like his actual device that he owned in 27? Like, forget about triangulating, forget about geofencing. It's like you keep saying, like, the device itself should have some information. Now, I've seen, like, I don't know what happens when we update. Like, it's still got to maintain, like, in the hard drive,
Yes.
they're going to be able to recover certain things. But, I'm not a
Every
phone
phone that
expert.
I've ever seen over years' time, I'm assuming at some point they updated their software or even changed their phones. But well, that would be coming, I guess, from the cloud, so it kinda depends, but, all the extractions that I've seen tell you at this time, you know, he searched on the internet for something, so you'd be able to see between these hours, was he responding to texts? Was he sending texts? Was he searching the internet? Was he using the ticker app or, doing whatever? And again, we all saw in Murdoch what's possible as far as just the cell phone itself.
Yeah. I mean, I just don't know what they're trying to suppress here. You know what I mean? It's like when you and I go in on a motion to suppress, we're giving the statement that we're seeking to have
I
suppressed.
I might not give the statement. I would just say on this date and time there was a statement. He made a statement against interest. He made a statement,
Okay, maybe
whatever.
not in a high profile case. We've never filed a motion where we haven't said, like on just a regular case where we're trying to suppress something, where we're trying to suppress this statement wherein our client said such and such, and then we give the factual background.
I don't know. I mean, I think it could just be on this date and time, you know, he made a statement.
Yeah, but we're talking about 2 hours and 40 minutes of date and time.
Right,
Like the
any statement on that date and time. I mean, you're not gonna be able to get into evidence unless that they somehow accuse him of, like, changing his story would have to be almost changing your story at trial. Like, "Well, that's not what you said during," are you getting in his denials? That they're never letting denials in unless it's to prove an accusation that you're lying now. So let's say I get on the stand and then during cross examination, they try to imply that I've changed my story or I just created this, I'm just saying this all right now because it's real convenient to be my story for trial. There's something called a prior consistent statement. That's the only time you're getting a prior consistent statement in is to, re- rebut an allegation or implication that you're lying, that you've just created this story now.
Yeah, I mean, I don't know. Like I'm just confused. Like Michael Osbrook's in the chat, he's saying they don't want to expose the statement to the public now, but Baldwin's saying flat out in the pleading that he does nothing in the thing other than deny. So the only thing that I can think of is it's something like Allison saying something that could be misconstrued or taken as some kind of admission. Um, because like you're saying, like I mean, aside from impeachment, how are they getting? If it's not a statement against interest, how are they getting it in? I mean, like how do they get denials in? Like you said, the only way is going to be impeachment. I don't know. Like I'm trying to figure out the strategy behind this, and what throws me off is the fact of the matter that Baldwin says unequivocally in the motion that the entirety of the interrogation is Rick Allen denying involvement in any capacity. So
Right, that's why I'm saying it's something as simple as, "I was on the bridge at this time, I was wearing this." Like, not gonna make it any easier for them than it has
well,
to
I mean,
be.
they have the dueling thing, I mean, that's like the dueling statement is gonna puts him there. I mean, I don't know. Like, I mean, is Allen gonna try to turn around and say he was never at the bridge?
No, but he doesn't have to say if he's not taking the stand, w why do you want his words that he was there to make their job easier?
Well, I mean, they're gonna put Dan Doolin on the stand,
I
and they're
understand, I'm
gonna
just saying, I'm assuming that there's more details, more information, just, again, not to make the job easier for them.
all right, so aside from not really, like, kinda understanding, like, the basis, and I mean, to me, like, a large portion of this motion is what Andy likes to do, and that's to put law enforcement on blast in terms of their bad behavior. He likes to get it out there. I mean, like the reality is I don't know how many people in Allen County are paying attention to this case to where it can have an impact on the potential jurors in this case. I mean, certainly it incites all the people that are following this case. I mean, you and I both know that cops do this shit all the time. I mean, to me, I didn't read anything that was shocking. It sounded like every police interview I've ever encountered. They're always doing shit like that. They're constantly lying. I tell people all the time, cops are the best liars. They're literally trained to lie. I mean, they use lying as an absolute tool in order to extract information from people in those interrogation rooms. I mean, they use it. The Supreme Court of the United States has told them they can use it in order to extract information, and they do. And they do it very effectively. They're trained. They go to seminars on how to lie, on how to interrogate. I mean, this is what they do. This is what law enforcement does. And, when they're getting the right guys, we're thankful for it to a certain extent. When they're getting people that aren't guilty, then we're not thankful for it. It's like it's the double-edged sword, and here, like, do you think just like forget trying to figure out what the motive is going to be behind the motion itself, right? I mean, I guess it's just a typical suppression motion. I think that there's,
Well, so I
I mean,
found
they're
this
really
case that says, and again, I think this is a federal case. Um, the defendant argues that St. Lawrence mere reference to Miranda warnings given the day before was inadequate. For the reasons discussed below, the court denies the defendant's motion, but I didn't get further. So sorry, go on. I thought I found something actually decent.
well, I was going to ask you, I mean, Ruiz is on point. It's an on point case, and I'm just going to pull it up so we can look at it. So this is the case that the defense cites. This I could pull up because it's not on my Adobe.
Oh, so you had to do the same thing I did. You had to specifically, that's what I had to do. It didn't give you the error saying, like, you have to go
No,
into your system settings and approve Adobe,
no, it was
whatever.
telling me like it had signed me out of my Adobe account, and I just put in like my normal email, and then it just started a new account. So I wasn't in my actual account. So like I wasn't seeing all the things I have saved, and I
All
didn't
right,
feel
go
like
on.
trying to
Read your
figure out the
read.
whole password while I'm on a live, taking a half an
Okay.
hour nightmare. All right, so this is the case they cite. And again, it's State v. Ruiz. And it's interesting in the sense that it really kind of breaks down um, what triggers a Miranda warning. And in the beginning, and this is an opinion by the Indiana Supreme Court, and it basically says if police interrogate somebody in custody without providing Miranda warnings, the person's interrogated statements are generally inadmissible as evidence against that individual in a criminal trial. And then they give you the factual background about Ruiz, and that it is on point in a lot of different ways, talking about the small windowless room and the secured area of the police station. Two cops tag teamed him in terms of the interrogation itself. Neither officer gave him his Miranda warnings. The multiple times that the officers told Ruiz that he was to sit tight in the interrogation room. So ultimately they get this guy to cave. Like, this guy ultimately makes an incriminating statement, against his own self-interest. And so, the Supreme Court then talks about the standard of review. And in this case, the state brings this appeal under the Indiana Code, which authorizes the state, because remember, the state is appealing this particular case, meaning that the state, once the appellate level, had reversed the trial court. So the way that it went down in Ruiz is the trial court, which in this case would be Gull, said, okay, like we'd all drop dead of shock if she turned around and suppressed the second statement, because we're so used to her denying the defense's motions,
Hey,
or at least
let me
the
let me
substantive
read you
motion.
guys something here, okay?
Okay.
So, now this is a Fifth Circuit 1975 case that they are citing in a 2021 uh, Alabama, Southern District of Alabama case, which says Biddy v. Diamond, this is that 1975 case. Collecting cases, the court says that when the case they're citing to was citing numerous cases, so a bunch of cases, and concluding that a re-administration of the Miranda warnings would have been needlessly repetitious, where the defendant was fully warned during a prior contact with law enforcement 12 days earlier.
So read that one more time. So that this is relating to that question that I was asking, whether or not the Miranda, the waiver that he signed on the 13th would still be in effect, right?
Yep. So here's one from 1987, says concluding that re-administration of Miranda warnings was not required where there was this was a same day break. But here's another one from 2009, 11th Circuit, holding that because the defendant had earlier been advised of his Miranda warning, his Miranda rights, there was no need to reiterate the Miranda warnings 12 days later at a subsequent interview that he initiated. That's a little bit different. So I'm going to keep
Wait,
researching because I'm not
wait,
satisfied
did
with that.
who initiated?
In that situation, the defendant initiated.
He initiated. Well, that's a completely different scenario.
I just said that.
Yeah, but what kind of defendant is initiating a conversation with the cops? It's like,
I don't
hey,
know, but this other one from 1975 said the same thing without
and
the
Indiana's the Seventh Circuit anyway.
I understand.
All right.
Thanks, babe.
All right. So
Wait,
you
what
keep
is
digging. I'm
Indiana and
gonna
Illinois in the same, you know,
yes.
same circuit? And would that
Um,
be the 7th?
yeah, that's Osbrook has to come to the great
I'm
city of
kidding.
Chicago to argue
Yes,
his shit.
I know.
Which the next time you come, call me because I'll meet you for lunch. Um, if you're still in here. Okay, so again, the standard review, and again, so if Gull had shocks the world and says, "Okay, Andy, I find your argument to be compelling. I'm going to suppress, everything that Rick said on the 26th." And McClelland's like, "Oh, hell no. Like I'm appealing this shit." And he files an interlocutory appeal, goes up, which I don't think he has time to do because trial's in less than a month. But, he goes up there because it can't be on the state's dime. So, but let's pretend like in a world that he could do that. He goes up, files an interlocutory appeal, and the appellate court reverses Gull. Says, Gull, you got this one wrong. Like this was not custodial. The statement's in. And then Baldwin says, "Oh, hell no. The appellate court's wrong." And then he appeals it to the Indiana Supreme Court. That's where Ruiz is with this situation, except it's the opposite. It's that McClelland, like it got overturned, and then McClelland appealed it up to the state Supreme Court. So the state brings this under Indiana code, which authorizes the state to appeal an order granting a motion to suppress if the order ultimately prevents prosecution of at least one charge count. This kind of appeal we have recognized is one from a negative judgment. So it is true that Ruiz filed the motion to suppress his statements, but no matter Ruiz's burden to support his challenge to the statement's admission, the trial court, in granting his motion, necessarily determined that the state failed to carry its countervailing burden to prove that the statements were admissible. And they cite Colorado v. Conley. Specifically, since Ruiz brings his challenge under the federal constitution, the state has to show by a preponderance of the evidence that Ruiz voluntarily waived his Miranda protected rights before he made the statements. And they cite the case law there. So the state also bore the ultimate burden at trial to prove beyond a reasonable doubt. So since the suppression order rested on the state's failure to carry its burden to prove the statement's admissibility, and that decision precludes the state from further prosecuting a criminal charge, which the state had the burden to prove, the state appeals from a negative judgment. Accordingly, the state must show that the trial court's decision was contrary to the law, meaning that the evidence was without conflict and all reasonable inferences led to a conclusion opposite that of the trial court. The state cannot make the showing if there is substantial probative evidence supporting the suppression ruling. Here, the trial court suppression decision was proper if Ruiz was under custodial interrogation, which triggers Miranda. This is where it gets interesting. This is the part that I really wanted to get you guys to, because the state admits that Ruiz was under interrogation. We focus our review on the trial court's determination that Ruiz was in custody. Here, I don't know that the state has conceded either. I don't know that they've conceded that he was under interrogation. I think by the nature of what we've seen, at least
They're
in
gonna
terms
find it
of
was
what was.
custodial.
Well, I think they're going to find that that was an interrogation and it wasn't
And I think they're gonna
exploratory.
find it was a custodial interrogation.
I do.
But I just wanna comment that the cases I'm looking at, the and that first one that I said from 1975 was, well, right before he answered the question, they asked, "Do you remember your Miranda rights? You were given those? You remember those?" "Yeah." "Okay." And there's even an
Oh,
Indiana case that says the same, although I can't open it right now, but
all right.
it's,
So Osbrook's making me feel way better. He's saying Ruiz is a federal law mess, and the standard review recited is bullshit. And for those of you who don't know who Michael Osbrook is, he's a professor at IU, Indiana University, and he heads their habeas unit there. He's got a bunch of students that dig around deep for cases that they think that somebody has been wrongfully convicted, and they find ones that they feel are winnable. And then what they do is they go and win them. So if anybody in this chat, including myself, is learned in the ways of Indiana law, uh, and especially in the ways of Indiana law that are useful tools in terms of getting um, wrongful convictions overturned, it's Osbrook. So if he says that the Ruiz is a federal law mess and the standard review is bullshit, I'm going to take that to the bank. So
well, that
my
wait,
next
why is that
question
making
for
you
Mike.
feel good? Isn't that the case they relied on?
No, I said it's not making me feel good. I said it's
Oh,
making me feel not warm and fuzzy. So my question to Michael is throw me a case that's worth a shit so that I can look at that. Um, because that is yeah, like there's this deep part of me that wishes that Osbrook was writing all the motions in this case for the defense. But I mean, he's he was the contempt guy. He's not a part of the team like that, so he can't draft up the motions. He can certainly give guidance, though, I imagine. All right, so Michael, should I even continue to read Ruiz now? Now you make. I think it's at least instructive to kind of explaining the difference between or some of the things that courts can look at to determine whether or not it's a custodial situation or non-custodial. So for those purposes alone, I'll go on with this particular decision. And frankly, I mean, this is the law that he cited. So this is what I didn't check the treatment. I didn't see if this thing, like what it's got, if it's been red flagged at all. Um,
I think I brought
so
it up and oh,
is it still good
mm,
law? All
I
right. So
still
under
have it up.
Miranda v. Arizona, if Ruiz was under quote custodial interrogation, the police were required to give him certain warnings about his rights. And the absence of those warnings precludes the use of his statement to prove guilt. So that's obviously the famous Miranda case. The state acknowledges that Ruiz was under police interrogation, but contends that he was not in custody. Custody under Miranda occurs when two criteria are met. Okay. Now, this is instructive. First, because this is coming from roughly from Miranda. First, the person's freedom of movement is curtailed to quote the degree associated with a formal arrest. And that comes from Maryland v. Schatzer. And second, the person undergoes quote the same inherently coercive pressures as the type of station house questioning at issue in Miranda, and that comes from House v. Fields. We hold that the state did not carry its burden here to show that the trial court's ruling was contrary to the law. The record includes substantial probative evidence of circumstances that, taken all together, met both criteria of Miranda custody, and will address each in turn. So you guys understand that? So there's a couple things that trigger Miranda. One, that it's an interrogation, that it's not just exploratory, that it's not just, hey, come on in and we want to ask you some questions, and they're just poking around, trying to get some information from you, but rather you're getting grilled. You got the light in the face, you're sweating, it goes on for hours. They raise the temperature in the room, metaphorically speaking. They're coming at you hard, and it shifts from being exploratory to where you're being interrogated. And then the second thing is if they use inherently coercive pressures, okay, such as like starting with it being at the police station. I mean, for you out there that have been pulled over, just like on a traffic violation, people that don't deal with law enforcement on a regular basis or never say, think about how you feel when you get pulled over. You see those cherries blasting in your rearview mirror and you're pulling over to the side and people are whipping by you, staring at you. And, the cop walks up to your window, and asks you to roll it down. And, here, I need your license and registration, proof of insurance. And you're fumbling around and, oh, it's on my phone, my insurance. I always start yapping back, and Allison's like, shut the fuck up. Like, just be nice and quit being a jerk off. And I'm like, I'm not being a, so we start bickering. And then, the cop, that's kind of our shtick with the cop. She plays the good guy. I'm the jerk off. But just imagine yourself in that scenario. And that's just on a roadside pullover. Now put yourself in a situation where you're going to the police station under the guise that, you're trying to get your car back, and again, like you can look at this two different ways. You can look at it from the perspective of, okay, if Richard Allen is the guy, if he's the one who committed these horrible crimes, what are you feeling driving over to the police station that morning with Kathy sitting next to you? Like, have you kept this secret for all these years, 5 years, and this thing's like all of a sudden reared its ugly head again? Like in October of 2022, they come at you on the 13th pretty hard. They flat out tell you that they think you're the guy, so he knows, like on the 13th, that they think that he's the guy, I mean, they came at him hard. So he's not going to the police station. But then again, on the 13th, they get the affidavit, it sounds like, for the house and the cars, right? They search the cars. He's not arrested at that point. So, he's got to be thinking, all right, I think maybe I'm good, right? Like, I'm good. Like, let's go get the car. Like, we need both of us. I'll pick up the car, my car, I'll drive it back, and you take your car back. So he heads up there and probably thinking that he's in the clear, that even though they took a run at him on the 13th, that they've searched his house and that they've searched the vehicle and that almost 2 weeks has gone by and they didn't arrest him for shit. So, like, in his mind, again, like, then we have to put ourselves, if he is the guy, is he sitting there, well, shit, I think I might have gotten away with this. Or if he's not the guy, is he thinking, this is a giant pain in the ass. They've had my car for 2 weeks. Like, instead of like bringing it somewhere convenient or dropping it off at my house or whatever, I got to go pick it up. So we're driving up there and he's not expecting to be grilled, so he goes up there. He just thinks he's picking up the car, and until trial, when we start seeing what evidence they have, I don't know which person he is. Osbrook, Michael is pretty convinced on what we've seen that they got the wrong guy. Based on what I've seen, I'm leaning that way myself. I lean innocent. I always have since the day that the PCA dropped. It's always been my position. They got to have more. So once he gets there, I think it's pretty clear that Holman's interrogating him immediately. So then I think you have to go to the second thing that triggers Miranda, which is whether or not this thing is, and what Allison's diligently looking up, because she's already said that she believes, based on the facts that we've seen, that Miranda's been triggered. So in Allison's estimation, Miranda should have been read to him again. What she's trying to find out is whether or not that waiver that he signed on the 13th, whether it extends to every time he's questioned in perpetuity.
Well, it's going to make a difference if the court believes that he said, hey, you remember those warnings, right? And that Richard Allen said, yeah, I got them. So I opened a case, State v. Diego, that's distinguished, and that's a 2021 Supreme Court of Indiana case that distinguishes from ER. And what they say in this case is that the present case admittedly resembles certain circumstances in ER. Like ER, Diego and Martin testified that an officer told them that Diego needed to come to SPD to talk to Mr. Troy, and then the couple arrived there. That there were they testified to varying degrees that they entered the lobby, went through a door, and then an elevator, rode an elevator up. They were separated when they met with the detective. And while perhaps not as labyrinth as the route described in ER, evidence favorable to suppression indicates they made this journey with minimal assistance or guidance from SPD personnel. Finally, though the interview with the detective and the personal was in his personal office and not in an interrogation room, the door was shut and the blinds to the interior building were closed. Diego was outnumbered 2-1. Detective Munson and a Spanish English interpreter who was an employed as a dispatcher. They go on to say, but beyond these aforementioned circumstances, we conclude Diego's freedom of movement was not curtailed to the degree associated with formal arrest. And they go on to say that the tone and tenor of the interview was certainly less dramatic than that in the ER interrogation. I think here it sounds like we had a similar tone and tenor to that in ER, right?
Yeah.
And that at the start of the interview, Munson informed Diego, and Diego understood that he was free to leave at any time. Munson's interview style remained constant. No additional statements like sit tight were made throughout the interview, and that would have made a reasonable person feel that they could not leave. Again, they say the interview took place in a personal office with 2 exterior windows and family photos, as opposed to the standard interview room with a couch, table, and chairs. The translator was dressed in civilian clothes. Overall, this presented a more casual atmosphere than the pressure cooker present in ER. And he told the truth. Detective Munson was very truthful with Diego. He listened to a conversation between Diego and the victim's father, and that lying about the situation wouldn't help. So he did say that. Although the detective suggested that he personally talked to the victim, he had in fact reviewed the LPD, a different law enforcement, police department, interview of the victim to hear her version of the alleged events. Towards the end of the interview, the detective asked Diego if he wanted to write an apology letter to the victim, but did not require him to do so. Taken as a whole, the line of questioning was exploratory rather than accusatory or aggressive. So they used, very little things to make the difference. I think, but I forget who you said was commenting, because I was sort of reading, and I've got an Indiana lawyer, it sounds like does a lot of appellate work, that says the ER case has got some issues. But
Michael
if that
Osbrook.
were right, so if that, like based on what they're saying in Diego, some of those things for whether he's in custody would still be applicable. I think that this was a custodial, but at the end of the day, I think, what did he sign a waiver the first time? So
Yeah, he signed a waiver the first time. I mean, look, like everything. So the way that they break it down in Ruiz is, under Miranda, freedom of movement is curtailed when a reasonable person would not feel free to terminate the interrogation and leave. Like there's no way that Rick Allen thought that he could walk out of that room. Like there's just, people don't even understand when they're pulled over for a DUI that they know that they can refuse to blow. But I have never had a client ever that understood that they could also refuse to do field sobriety tests because they don't feel like they can refuse that. People just don't know their rights in that way. They don't know what they can and can't do.
Yeah, but what their rights are sometimes isn't what they can or can't do, which we've seen hundreds of thousands of, maybe I'm even understating, by thousands of times, when a black person doesn't want to get out of the car or questions why they should have to get out of the car when the cop orders them out for no reason. I mean, sometimes, you got to wait on your rights because the cops are acting like you don't have them anyway.
Right. But my point being is that
Right.
any person, especially a black person, would never think that they were free to leave. That's fact. Like no normal person
No, when you're told to sit
in
tight, you're
especially in
pretty
this
sure
type of
you're supposed to sit
situation.
tight.
Yeah, if you're you're in the police station and they've got you in a room, you do not feel that you can just leave. I
And for
mean, they
anyone
just like
listening out there, you can just say, Am I under arrest or can I go because I want to go now?" And then if they
right.
tell you no, that's what you tell your lawyer, that they told you no. And the other, suggestion, anytime they give you your Miranda warnings, they give you a little piece of paper, and they say, "Just sign here, just to show that I gave these to you." Don't initial and sign, just write, "I demand a lawyer," then sign, or don't sign at all.
Thank you. I was waiting for you to say that's the first thing that you do in that situation is you ask for an attorney. You don't answer any questions. Always. Like it doesn't make you look guilty. It makes you look smart. Okay. Because especially if you're innocent, my God, like the worst situation is being in an interrogation room with cops when you're innocent and you're letting them come at you. If they've got you in a room, just understand you may know you're innocent. If they've got you in a room, they don't think you're innocent. They're looking at you beyond just a cursory glance. They're staring hard at you. They're going to try to work you in that room. That is why you ask for an attorney and you have to say the words. I'm not saying another word. I want my lawyer. I'm done. That's it. And you end the interrogation. You end the conversation. By law, they have to stop interrogating you at that point. And anything that goes on beyond that is inadmissible because you've asserted your rights. It's unequivocal. It's the first thing you do. You don't answer a bunch of questions because I mean, cops are very skilled, just absolutely skilled at getting people to start talking. Like they're man, we're trying to help you out here, dude. Like we're just trying to help you out. Like just all we need to do is understand this one thing. And once we understand it, you're out of here, dude. You're walking. So they get you, they're trying to help you. They're your friends. They're never your friends. They're never trying to help you. They're always trying to get you to make a statement against interest or get you to talk. And once you start talking, words can be twisted. You see it all the time. Words are twisted, words are taken out of context, and then they're used against you. I mean, there's a reason that they have to tell you that anything that you say can and will be used against you in a court of law. There's a reason that that's in the warning because they will. That is exactly what they're going to do. So here the state argued that Ruiz's freedom of movement was not curtailed, as thus he was not in custody. The state points to certain evidence and support. Ruiz provided his own transportation. So did Rick. The first interrogating officer told him, you don't have to talk to me. You can get up and walk out that door at any time. Ruiz sat near the unlocked interview door and had not been arrested. And the interrogation lasted less than an hour. And Ruiz left unhindered after it was over. The evidence does indeed point to no custody, but substantial probative evidence in the record points in the opposite direction and supports the trial court suppression ruling. So that's where it gets interesting because, like, when you just look at those facts, the guy left. Like he got up and he walked out, but they dug deeper. They dug deeper, and this is where it's on point with a lot of the stuff that was going on in this interrogation of Allen. So to start, the time and the place were directed by Greg O'Brien, the cop, who showed up at Ruiz's home, informed him of the allegations, and explained that he needed to interview Ruiz and asked him to come to the station. Importantly, Detective O'Brien did not inform Ruiz that or any other time or place would suffice for the interview. defendant returned officers calls to set up a meeting. The officer asked defendant where it would be convenient to meet. So Ruiz goes to the station shortly after getting dressed. O'Brien then leads him through various sections of the station house, from through the lobby, through a door that required a key fob to enter, which is typical. You're not able to walk into the guts of a police station ever unless they're escorting you in. Into a secured area containing the police squad room, up the elevator and the stairs through a second key door that was propped open, and into a small interview room with no windows and a single door, which the officers closed for the interrogation. Although he was not handcuffed or locked inside the interrogation room, Ruiz was physically and visually cabined to the small compartment with officers positioned near the single shut door. So same deal, small room, Holman's like, and that's like, when I first read it, I'm like, why? Oh, this is a good question. This is a good question. No, we're not. Like, we don't go to seminars on how to lie. We just don't.
Lawyers?
Like, yeah, lawyers. He's asking our defense attorneys trained to defense attorneys and prosecutors go to the same law schools.
Right. They
So,
do.
I mean,
They often, intern at the same places and sometimes work at the same places
they
at
do.
different times.
Yeah.
So
So
one thing
no,
I want to note is that, like I said, I'm feeling pretty strongly that if the court believes, although it's not recorded and not, there, that the detective asked Richard Allen, "You remember your Miranda warnings?" Yes. That might be sufficient. One thing I was trying to figure out is, like, we've got a different officer here that was interviewing him, but it's at the same police department, right?
yeah. Well, if you look at the where did Baldwin come up with all that language that's what happened? Like, who like, can you pull? See, that's why I just had that.
I've
Wait,
got it
I
in
might be
front of
able to.
me.
Like, where does Baldwin come up with this whole thing that's what happened?
I
All
think he
right,
says it's
here.
in a police report that
He says it's a police report.
yeah, uh,
Okay.
so let's see.
Okay. While you're looking at that, I want to keep going with this because it's instructive. It gives people an idea. Um,
Oh, well, let me just read it to you so you can go on. It says, to make matters more suspicious, Holman claims in his November 1st, 2022 report, memorializing his October 26th interrogation of Rick Allen, the following. I asked Mr. Allen if he remembered the other detectives reading him his Miranda rights, and he said yes. I told him he was free to go at any time and the door was unlocked.
I mean, like, Baldwin's got a point. Like, why doesn't Holman just make sure when the recording starts that he's reading Ms. Miranda, right? Like
Almost
the one,
universally, even if that actual thing is not on the recording. I have never, ever had the recording stop where the officer doesn't say, before we did this, we went through your Miranda warnings, either says like that piece of paper and you signed it, or, whatever, and you understand that you've got a right to counsel and you're agreeing to talk to us. Yes. Like
right.
something.
Right. And you know why they do that? Because defense attorneys file motions to suppress statements, because when they don't do that, or when they hadn't done that in the past, it ended up resulting in statements being suppressed. So that's the point when I'm always trying to tell you, don't blame the defense attorneys for filing motions when the cops aren't doing their job properly. Blame the cop for not doing their job properly. And here, where it's clear that Holman and probably everybody else associated with the unified command knew that Rick Allen was not walking out of that building that day. They knew that he was coming there, and they knew that they were placing him under arrest. So just to dot his I's and cross his T's, I do not understand why Holman wouldn't have made absolutely certain that he read Rick his rights again, or had him sign another waiver, or did at the very least what you mentioned, make sure that that's on the audio and the video where he's saying, look, you
You
know, you
remember those
signed that
rights from
thing
the other day?
before, you remember the right, all that. Like, why isn't he doing that? It's bizarre. You know, when they know this is going to be a huge arrest, they have to know that this case is going to turn out to exactly what it's going to be. I mean, whatever the case is as to why Diener recused himself because of the bloodlust associated with this case, law enforcement is aware of the same bloodlust. Like, for him to be so sloppy on the arrest of the person that they're going to march out and have a press conference and say, we got our guy. Why are they being so sloppy? Why is Holman being so sloppy? Why are the people that are sitting outside peering in that room while he's doing what he's doing, which you know was exactly what's happening? They're always somebody watching what's happening, either sitting on the double-sided glass, or they're watching it on the monitor, what's happening. I mean, and it's like, when he says that, sit tight for a bit, that's him going out and talking to whoever's standing out there with him, whether it's Carter, whether it's Liggett, whether it's all of them. They're all standing there. And so in my estimation, all of them let that happen, knowing that he started the recording. So, I mean, ultimately, I don't know, man. It's just like everything with this case, with how they handled it, just makes everything seem shady. I mean, they knew all this going in. It'd be
For
one
sure.
thing if like they didn't know Allen was going to be arrested that day, and Allen came in and he spills his guts. Okay, well, I didn't know he was going to do that. I didn't know, like, that's not what this was. This was them saying, yeah, we'll give you your car. Come on down, and we'll give you your car. And it turns into a almost 3 hour interrogation. Okay, so when O'Brien started to question Ruiz, he told Ruiz a single time that he could walk out the door, but the trial court did not err in concluding that the statement was not enough to make a reasonable person feel free to leave for 3 reasons. First, the officers told Ruiz to sit tight multiple times. Ditto here, belying any prior indication that Ruiz was free to go. Second, the circuitous path by which O'Brien took Ruiz into the interrogation room drew a labyrinth exit route with many obstructions to egress. One of the doors O'Brien led Ruiz through required a key fob when heading down toward the interrogation room, and nobody told Ruiz that it was unlocked going the opposite direction. And finally, and most importantly, the police significantly, and I don't know, like, we didn't get the description of where Allen is in the West Lafayette police port. Like, I don't know where he's at. Could have been like he walked in the door, like, who knows? Like, we've
But you
been to
do know
police
it was the
department.
same police department each time, right?
I believe that it was West Lafayette both times.
Okay.
Like, I think, but like, I don't know. I'm not 100% on it. Like, you have the motion, you could check. It'll tell you.
Oh,
I can't pull it up. You're frozen, by the way. I think for me. I don't know if you're frozen for other people.
am I still frozen
Um,
for you?
no, now you're not. You were frozen. It was a real cute, like, frozen position though, so that's good.
Thanks.
Um, Finally, and most importantly, the police significantly undercut any initial message of freedom when they dramatically changed the interrogation atmosphere. Shortly after O'Brien began the interview, a second officer, whom Ruiz had not met yet, entered the interview room, shut the door, and took over as the main, more aggressive interrogator. In this way,
Hey,
the
this
police
seems to
complete.
say they went to the so one is at the West Lafayette Police Department and one was at Delphi.
Hey,
So,
Darren's in the chat. What's up, D?
Hi,
D
Darren.
makes the elusive appearance on YouTube. That's our producer for our podcast, Darren Wood, and more importantly, my friend.
Our friend,
What's up?
who we love
What's up,
dearly.
D? Yeah, we do.
Uh,
We do.
so it
Um,
was in October 22nd. This says it was the Delphi Police Department. The second time they were dealing with the state police and then went to the Lafayette Police Department. So those two factors, different setting, different officers, different agency, are going to play in favor of finding, in Rick Allen's favor, of finding that Miranda warnings were needed again.
okay.
But we know our
All right.
judge. So
We know our judge. So, okay. So the more aggressive cop comes in, and the police completely recast the interrogation, subverting the force and applicability of O'Brien's earlier walk out that door statement. At no point did either officer say anything to preserve that statement's validity. Other statements the officer said or admitted, along with the character of their questioning, point toward curtailed freedom of movement. Again, when you're looking at what this was with Allen, this was a heated conversation where Holman's telling him, fuck you, I know you're the guy, and Allen's telling him, fuck you, I know I'm not the guy. You know, you don't have shit on me. And Holman's saying, I got everything I need. You know, I'm gonna prove it. I know you did something, and I'm gonna prove it. Which, for those that are of the torch and pitchfork crew, that statement there, which is a direct quote from Holman right before he slaps the cuffs on Rick Allen, should speak volumes to you. When he's sitting there saying, I know you did something, I'm going to prove it, tells you at the time that they arrested him that he felt like he still needed more to prove it, that he did something. He didn't know what it was. I mean, that's a very telling statement to me. I don't know. Is it a telling statement to you, Allie? I don't know.
which one?
The one that I just said, where
Say it
he
again.
said where he tells him, where he says exactly what I just said. Oh, you weren't paying attention. Pull it up. It's the thing, like where Holman says, I know you did something,
Oh
and
yeah.
I'm
Yeah,
gonna
yeah, yeah.
prove it. You know what I mean? It's like, and that's right before he's arrested. Like that act right there, that's when he's arrested.
Right.
Like he's saying, I know you did something,
You're guilty of
has no
something.
idea what he did.
You're guilty and I know it, and I'm gonna fucking prove it.
Right. Like, I mean, that's what your cop's mindset is the moment the arrest takes place.
Yeah,
So, I mean,
and that bullet that I think several, you know, other people having nothing to do with defense attorneys have said that
I
that
don't even want
science
to
is in
talk about the
question.
bullet anymore until trial. I don't know where it was found. I've heard everything. I've heard
Well, I
that it
hope
was
that's one of the
like found.
experts that they get. I can't imagine that it's not.
Well, I just hope that we get like an actual like time and date as to when the thing was found, because I've heard so many stories. I have no idea which, like, that's why I never talk about the facts, because I don't know any of them. Like I've heard, the woman with the, like, weeks later, a woman with a metal detector found it. I heard that they processed the scene, they shut it down, and then they reopened it, and that's when they found it. Like a week, 2 weeks later, I've heard that I don't know. It's like the whole thing. Like, I'm just ready for trial. I just want to hear the facts. I'm so sick of everybody talking about it. It makes me like physically ill. Um, okay, the officers did, however, repeatedly tell Ruiz to explain to them what happened, coaxing him to, quote, tell us now so that we know that you're being honest with us and not lying. The officers were explicit that they believed Ruiz had engaged in the accused conduct, and their questions were accusatory, not exploratory, like ones to identify suspects in the early stages of an investigation. Munson emphasized this with deception, saying that this person who made the accusations had passed a lie detector test. Now, like, as we were saying, when Allie and I first read this, I'm like, why? why is he like putting in bold that the cops lied to him when they're allowed to do that, not realizing that he's trying to build his case that this was custodial? You know
And
what I mean?
involuntary. Right.
And well, yeah. Um, but he didn't make apparently he didn't make it to any kind of inculpatory statements, at least at this point in this particular interview. So the questioning was also prolonged, lasting on almost an hour. Here it lasted 2 hours, 41 minutes. Although the length of an interview alone does not determine whether a person is in custody, the question here was sustained and relatively drawn out, especially compared to roadside traffic stop questioning. And the officers continued the interrogation past the time that they knew Ruiz was supposed to pick up his daughter, telling him to sit tight until they were satisfied. Indeed, the interrogation did not end until after the officers had extracted incriminating remarks. Altogether, the circumstances surrounding the interrogation added up to a situation in which a reasonable person would not feel to end the interrogation, would not feel free to end the interrogation and leave. So the record supports the conclusion that the curtailment of movement criterion was met. So, and then they get into the coercive stuff, and the coercive stuff is like the lying, you know. The state devotes a little attention to this specific custody inquiry, but it does argue that Ruiz, quote, was never coerced to cooperate in exchange for freedom. That didn't happen here either. We disagree, as the record includes substantial probative evidence to the contrary, and overall, the station house questioning both resembles the Miranda paradigm and exhibits the coercive pressures that Miranda targeted. The interrogation here was not a brief roadside questioning or interrogation in the low atmospheric pressure of a suspect's typical surroundings. Rather, it took place at the cop shop in an isolated room, removed from Ruiz's friends, family, and familiar environment, with multiple cops employing various interrogation tactics for almost an hour, trying to convince her suspect to incriminate themselves. So they also applied multiple layers of subtly coercive forces that together, in the absence of Miranda's safeguards, would impair their suspect's free exercise of the privilege against self-incrimination. First, after the interrogation began, the officers kept Ruiz, quote, off balance in the already unfamiliar environment. Munson, who Ruiz had not yet met, entered the room and assumed the role of main interrogator with a more aggressive style than that of O'Brien. Munson then used subterfuge, lying to Ruiz about the accuser having taken the lie box test, and then describing pressures that create coercion, including the use of deceptive stratagems. He also counseled Ruiz that the alleged conduct was not a big deal, but the Ruiz would look bad if he wasn't forthcoming about it. And the officers intimated that Ruiz's fate was in their hands. They suggested that if Ruiz didn't talk right then about what he had done, they would make things worse for him in the future, because they would worry that he wasn't honest, that he had done something more than the alleged wrongdoing. So other pressures piled on. The officers said that they knew the allegations were true. They engaged in prolonged, persistent, and accusatory questions that focused on encouraging Ruiz to admit to the officer's description of the wrongdoing, and they instructed Ruiz to stay put in the interrogation room while the time to pick up his daughter passed. These types of coercive pressures applied in a station house interrogation are precisely what induced Miranda's warning requirements. So the second custody criterion, like the first, was met. So, I mean, that's basically it. So I agree with you. I think that both things have been met here. And I think it's still going to be denied by Gull. I think that she'll put Holman on the stand. Holman is going to say, "Look, Your Honor, I asked him flat out, did he remember his rights? It was just a couple weeks ago. It's a big deal. We had a big conversation with him then. He knew his rights then. I asked him if he remembered them. He said, yeah. I said, okay. You know, you can leave at any time. I told him that. So I think that she's going to find that sufficient, and I think that you're fervently trying to find the case law that she's going to cite to support her decision on this live.
Well, the Supreme Court has said that one of the factors that they consider was whether it's the same officers in the same agency doing the questioning.
Different
So
officers
and it's
and
at a
theoretically
it's
different agency.
right, he's at a different police department. Um,
Was he where
but
was the first one? Where did the first one take place?
Delphi,
Oh, the first one was in Delphi? Okay.
yes.
And plus, I mean, we're talking about the unified command. Are you on the basement?
I am, but because I'm not, like, moving my computer around enough, it's going into, like, sleep mode. That's what keeps happening, actually.
Oh, is that why you're freezing?
Yeah, and
Oh.
then when I when I, like, wake up the computer, you're saying you see me, so,
All right.
um,
So
I take that down, you're done with it,
hopefully
right?
y'all have like a good understanding of Miranda and kind of what's been argued. And this is the case that Baldwin cites in the motion. So that's what he's going to rely on if it goes to hearing. I anticipate, time is of the essence here. Like I don't know when, and I anticipate that there's going to be a flurry of motions in limine that are going to be filed by both sides leading up to trial. That'll probably happen in the first week, or the last week leading up to trial, where we'll see all the motions in limine. Like
And that,
I
by
don't
the
know.
way sorry.
Go ahead.
No, 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 you were literally mid-sentence. I'm
I
trying to
was
get
just
better
gonna
with
say
that.
I don't know. I don't know that they have the time to
I was
spend the day in Delphi or a half of a morning arguing this motion, to be
well, I
honest
thought
with you.
they were changing it, like, that all the
They
is
are,
Delphi
but it's yeah, Delphi is Carroll
the
County.
new oh, okay, so that's where it would all
No,
be.
that yeah, it's closer, but it still eats up a morning that you can ill afford when you're on the eve of trial, and believe me, we are on the eve of trial right now.
I
Like,
understand,
these
but they're
guys.
gonna have to get these heard before because I'm assuming they'll have tons of motions in limine, and that's what I was gonna say, motions in limine might be where you and I actually mentioned this on the other live, like, where you hear other arguments that don't deal with, um, constitutional issues for keeping out these statements and the statements to the family members, um, that might be done in a motion in Lemonade talking about, as I believe I mentioned before, that they're unreliable for some other reason, also dealing with his mental health,
Yeah, I
more
mean,
prejudicial than probative.
if I'm Gull and I'm wanting to play it safe, if I'm trying to curb the tide of this thing's going to get overturned on appeal, I'm like 100% setting a hearing.
You would
Even
think.
if it's a quickie,
Now I
like
have
I'm
to
just
say, I don't like that he didn't say, and I don't know Indiana law. I know you've got someone here that knows it very well. I don't know if he's still here because I just looked at the time and it's
all right. So
10:48.
Michael Osbrook, he's the one who wrote like
Right,
the
Michael,
excellent,
that
yeah.
right, that you would want to put, an affidavit from your client that Miranda warnings were never given to me on the second occasion, and hopefully he did not ask me if I recalled my Miranda warnings, that type of thing, because all that's being alleged in this motion is that according to the recording, this never happened, and it should say, according to Richard Allen, this never happened.
I think the problem is twofold. Alan's like, I don't know, 2 hours plus each way for them to drive and see him. I like they don't have time to be
It's
driving
the
to
first question you
Wabash.
ask. We all know this. It's the first question you ask. Did they read you your Miranda warnings? I mean, it's been
What do you mean?
asked.
You like when they were first retained or when they were first
Yeah,
appointed to
the
the case?
first time they interview him. Did you make a statement? Did they read me? How many times were you interviewed, and did they give you your Miranda warnings? Did you sign a piece of paper? Did they threaten you? Did they I mean, that's the first thing you're asking in the first, you know
I mean, it's the first thing that we ask.
I'm
I don't
just
know if
saying
it's the
I would
first thing that
suspect that, you know, any lawyer would.
well, if that's the case, then why didn't they file this forever ago? You know what I mean?
It's
It's like,
it's a very good question.
I don't know.
I don't know why they didn't file this forever ago.
I mean, I think the fact of the matter, like, if I had to hazard a guess, I would say that, you know, when they lost possession of the discovery, when they were removed from the case and then got it back, I don't know if they were through it all at that point. You know, I mean, they're like, this is a
Then
different
don't try to go to
situation.
trial.
Well, that's a whole different issue. That's a whole
So,
different issue.
yeah. Um, I forget what I was thinking.
I mean,
Trying to
I don't know that Gull would grant a continuance at this point.
Well, it sounds like I mean, the only other reason they might not have an affidavit from their client is, because I think there was something in the most recent filings that he's better, or maybe I'm going off what you said actually, like that you said he looked better. His, he seemed to be like at least with it in his eyes and his face, but it could be that they're just, you know, not sure on his ability to sign an affidavit, but, you have to make a preliminary showing that you were that your statements were involuntary without warnings, and then the burden shifts over to the
So
state, but I don't.
this wasn't provided them. Yeah, and Angela, that may be true, but what Allie's saying, like anytime we pick up a case, like the first conversation that we're having, and I'm just talking realistically, is did you talk?
I know,
It's the
but
first
wait,
thing that we ask.
but they're saying that the defense didn't get the defendant's statements until February 24th.
That's what they're
Is that
saying.
okay?
That's
Well,
what they're
then that should be a motion to exclude them for discovery violation. I mean,
I mean, they've been trying all that. They filed these kind of motions, like you know, I mean, they've tried all that. You know, I mean, like, but to Allison's point, like we just asked that question, like anytime at the beginning of a case, it's like the first, like, did you talk? It's the first thing we ask. The first thing that we ask is,
right,
did
but
you
he would
talk?
have said, "I didn't say anything, I denied it, I told him I didn't do
Right,
anything." You know what I
right,
mean? So he's definitely
exactly.
not gonna remember, like, any little details that, you know, the defense may want to get out. So I didn't realize that they just got his statements, in February. And when did that 70
Right, and
days
beyond
start?
that, they also had to, like, re-go through everything because remember, they turned all of the evidence over back to McClellan. McClellan then turned it over to Labredo and Scremin. Scremin, once they got reappointed, turned it back over to McClellan, and then McClellan turned it back over to them in February of 2024. So, and they had to re-go through everything. They had to double check and make sure that everything that they had cataloged prior to was still there, made sure that things weren't missing. I mean, they had to like process all of the discovery again. So, I mean, there's reasons as to why they didn't do it earlier, but you know, I think that the bigger issue is that exactly like we wouldn't have asked the second question. Like if he had said, I didn't say anything, I didn't say, yeah, I mean, I
Yeah, I think
talked,
I do. I
but I
usually say
didn't.
to them, "Tell me exactly what they asked you and exactly what you said, even if it wasn't an admission. Tell me everything you guys talked about." I do always ask that, but what I'm saying is there could have been several small details that weren't significant enough in Richard Allen's mind to reiterate back that now that the
Oh
defense
yeah,
is seeing it in black and
especially
white.
yeah, especially for a 2 hour and 41 minute interview. I mean, there's tons of shit he's not going to remember. Plus, you're like in that moment, you're like where your head's exploding. You know, you're sitting in this room, and again, if he's an innocent man sitting in that room, you're freaking the fuck out. You
And
know,
I'll tell you another thing that I think is gonna play against Richard Allen in his,
and if you're a
you
guilty
know
man, you're freaking the fuck out. Either way, you're freaking out in that room.
so, as far as the factors that are mentioned in this motion is that he the first time I can't remember actually if it's the first or the second, I think it was the first, whenever he's like, yeah, you're accusing me, I'm done, I'm out." So kind of an understanding that you can leave and that you can say you can cut it and call it. So that's probably gonna play against him as far as,
All right.
you know,
So QB Designs has this question. So that's my question. If Gold denies it, she'll have to hear it during the trial, not in front of the jury. No, that they would pull the jury. Like if this thing got all the way to where she didn't hear the hearing or have a hearing prior to trial and the issue comes up, yeah, they'd have to argue it
is Michael still
at
here? Because I saw someone said at some point that, there might be a jury instruction in Indiana that puts it on the jury to decide whether they think the statement was actually given or voluntary. I don't know. I can't remember what it was, but something about a jury instruction. So, if the judge when she asks if the judge denies it, what is it? A hearing? Going back to the question you just had up before
oh,
this one?
so let me see. I like AEOD's question here though too. Um so that's my question. If Gull denies, she'll have to hear it during trial. QB, I don't understand what you mean. If she denies it, like where she denies everything else without a hearing, then it's not getting heard at trial. She's denied it, and the if the state's trying to get something in, they're going to be able to get it in because it hasn't been suppressed. So
Right, but if her
if,
question
if
is
she
if
does
they
nothing with it, and then the
right.
issue arises at trial, at that point, she's going to have a hearing outside the presence of a jury.
Right, but I would suspect she's going to have to take this up beforehand because you've got opening statements, and opening statements can't, you know, obviously you can't mention. So yes, she said without a hearing. So I would suspect, yes, would have to be heard outside the presence of the jury. And but it could be heard maybe like after they select a jury, but before openings, or okay, you can't mention any if we don't do this now, you can't mention it in openings, so um I suspect it's gonna be beforehand. And I actually saw Mia Bito's, comment, and I'll tell you my answer to like my niece who answered that question, and yes, it's because of the Constitution and all of that, but also, when the evidence demonstrates that our clients are guilty, what we're doing is trying to negotiate the best deal for them, pointing out mitigating information, trying to get them mental health, you know, their mental health addressed or things like that. So, we're just making sure that that s- oftentimes the state charges way overcharges. People always say to me, "Well, I don't get it. There's 5 charges here, but I only did one thing." And I was like, "Oh, yeah, yeah. That's just 5 different ways, possible ways that they could find you guilty for the one thing. They can't get you guilty on all 5." But then sometimes they do things where they charge, you know, multiple different ways that could actually be multiple charges and multiple offenses and aren't like lesser included. So that's the other thing that, defense attorneys are doing, making sure that the charge matches the actual offense and he's not being, you know, he's not having charge on top of charge piled on. So it's not always us just getting guilty people off or even trying to get guilty people off. Sometimes it's trying to get a guilty person the right, you know, the right sentence
I,
and
I
have the
would
right.
hazard to guess that that's a vast majority of the time is working out plea deals and making sure that people aren't getting railroaded, or we want to make sure that the punishment fits the crime as much as we can. I mean, that, like, most cases plead out. Like, I mean, I don't know how many times I have to say that. Like
Right, it's just a
in the
voice on the other
90%.
side to say,
It's
"Well, he
right.
was he was a drug addict," or, "Well, what about all these he's done a lot of good things in his life too." So you need the balance, you
Okay, well, the
need
the
the other
easy
side.
answer is if there weren't defense attorneys, everybody that got arrested would just be thrown in prison forever. You guys like that? Does that sound like a fun country to live in? Sounds like a nightmare to me. I mean, but that's what it would be if you didn't have defense attorneys doing what we do. Like, I'm so sick of defending what we do. It's like bizarre. People like everyone should go and watch Ken Burns' documentary on the Central Park Five and just let that resonate with you for a few days about how this system of justice is really operates in this country. Just like watch it. It's about the Central Park Five. It's about that young group of Black and Hispanic 5 kids who, some white woman jogger is assaulted, and they got these kids pegged, and of
I
course
think
they didn't do it.
Cameron,
But
our 17-year-old just said she was had rewatched
man, we
it, and
raised that
she's
one
almost
right. We raised that one right.
yeah, her
She's a
stomach
she's a
already
freedom
hurt.
fighter.
Yeah, for sure.
She's a good egg, man. She's a good egg. Okay, wait, I want to go back to I liked AOD's
Oh, yeah,
question
there was a
here.
question.
Let me see where it was. Okay. How are we supposed to ask him when there was a camera pointed at his face to record all his answers, though? So harken back to when he was in Westville. Remember when I was giving you all the details about
Oh,
the June hearing, about the safekeeping hearing, and how they were going
right, so they
there and they
might
were
not have
filling him
asked
with
him a
the
lot of
info.
questions.
They
That's
weren't
right.
asking him any questions.
Right. I get it.
Right.
So, yeah, that's definitely an issue.
Yep.
No, it had
That
not
had not
already been asked and answered, and I had sort of forgotten about that issue, that their, inability to have free, open communication with their client.
Where did she explain it, Sleuthie?
And what did she explain?
Yeah, what did she explain? We want Kara's explanation. Like, where is she? Should have made her come on tonight. Bullied her
Yeah,
into it.
because, I mean, it's only 11 PM, Central Time.
I know. I had a long day with Jay, It's exhausting being on all day. Yeah, which by
Yeah.
the way, I know you guys were streaming the Daybell trial, which is boring so far, but will get interesting. And we're pivoting to the other most toxic case in the world, Karen Reed, when that thing starts, which the jury selection is supposed to start tomorrow. And Jay and I are going to cover that. What Jay doesn't know is if that thing doesn't finish, I'm skulking out of town and going to Delphi for this. So you're going to have to stand in my stead, babe, and
She
be
said it sounds like Carrot gave an explanation on X, on Twitter.
of which thing.
What someone just said and what we just asked.
Oh, okay. Let me see. Okay. I'm trying to look and see if there's any other good questions in here. If anybody had a question they'd really like answered, throw it. And
What's
we
her
didn't
X?
see it.
Or her
Kara Winicky. She's got a
oh,
couple of
just
them.
okay.
Oh, here. Sleuthy sent it to me. So, okay. So per Kara, per her tweet, she stated that in Indiana, there are 2 procedures a criminal defendant can employ to exclude certain evidence. The defendant can file a motion to exclude/suppress the evidence pre-trial. In most cases, the trial court will hold a hearing on the motion, at which time the defendant will have the opportunity to present evidence in support of its motion. If the court grants the motion, the evidence will not be presented to the jury. If the court denies the motion to preserve, that denial is a possible error to be raised on appeal. The defendant must object at trial when the state offers that evidence.
Yes.
What happens if the court does not hold a hearing before trial on the motion to suppress evidence? When the state offers the evidence at trial, the defendant objects. The defendant must be afforded the opportunity to present evidence as to why the evidence should be suppressed. If the court will not permit the defendant to present testimony from witnesses, which she's got in parentheticals would be unusual, the defendant will still have the right to present an offer of proof, which is essentially a presentation of all the evidence he would have presented had he been allowed to do so. To make matters even more confusing, that offer of proof can be done by presenting testimony from the very witness that you sought to call to support your motion to suppress. The problem with that? The hearing has to be outside the presence of the jury. In essence, you're holding a hearing within the jury trial. So you've got jurors sitting around doing nothing, not ideal. This is why most defendants don't employ the second option to exclude certain evidence, which involves not filing anything pretrial and just objecting to the evidence and moving to suppress at the jury trial. Again, judges don't like that because the
I
jury
was
has to
gonna
sit around
say,
while a hearing on the motion is being conducted. Given the lack of pretrial hearings held thus far in Delphi case and the limited time remaining, you'd think a suppression hearing won't take place. But if that's the case, then the jurors are going to be cooling their heels in the jury room while these issues are litigated in court. There you go.
I mean, usually, typically before trial, a judge has set aside a couple of number of days to, like, address any, you know, things that haven't been addressed and take up issues and, you know, and all of that. So I'd be surprised if they don't already have, a date for something like that. And like I said, this is the kind of thing, does the defendant's statements get in that typically you can't wait until even objection and then be outside of the presence of the jury because of the opening statements. And it's not something minor where the state will say the judge might say, well, that's a risk you're going to take. You might say it in your opening statement and then not be able to present it at trial, and it's going to bite you in the ass because there'll be, it's surely going to be pointed out by the the defense in their closing. Well, what about how the state promised you this? You didn't hear anything about that, so but I
Yeah.
just feel like depending on we're not talking about necessarily these statements, but what about the other ones? I mean, those are
Oh, the
significant.
confessions?
Yeah,
Yeah.
those
Sure.
are significant that if, like, it would be highly prejudicial for something like that to get mentioned in opening, even if they can't prove it up at, that doesn't work. That little, well, you someone gets to point out how you never proved it, that's still gonna ring the bell.
Yeah. So, Richard, I actually thought the same thing. Richard Plunkett says that I think that they can say that RA was saying what good person kills two girls is basically admitting that he killed them.
I know
I mean,
that would be
I could
so
see
disingenuous. Like, it crossed my mind for a moment, but that should be another whole separate motion in lemonade. Clearly, that's not what the man is saying, but that's actually an argument that the
it's
state made in, not to bring up the toxic, Karen Reed case, at least what I saw from that little pretrial thing was the state said, "Well, she said right there in the booking room that, um, something to the effect of that she admitted that she hit his head on the bumper of the car," something like that, when what she really said, literally, her words were, I mean, we're all in on the same joke, right? You know that these 2 guys beat the shit out of him. "Oh, yeah, my car backed into him and smashed his head." Like, it was
right. It's like it's
clearly
the my cousin Vinny thing.
right.
Oh, I shot the clerk.
"I shot the clerk.
You
I
shot
shot the clerk.
I shot the clerk.
I
I
shot the clerk.
shot
I
I
did."
shot the clerk. I shot the clerk. Right. Yeah. I mean, it's like
Excuse me,
context is
everybody. He
everything.
admitted on at least 4 occasions to having shot the clerk. But
Right.
yeah, he's absolutely right. I actually thought about that when I heard it, like, "Oh, they're gonna try to just say that he just said there," I
So did
think
I. Like when I was trying to figure out what the hell he was trying to like suppress, like after he had said that everything was a denial, the only thing that I could think was that particular statement that they would try to twist it that that was Alan saying, well, what good guy, what good guy would kill two girls, and
right,
like that
"You're the
they're
one accusing
couching.
me of having killed them, so how could you think I'm a good person if you think that I killed 2 girls?" That's
Right.
clearly what he was saying, but that could also be addressed. And again, it goes to not having a lot of, I guess, faith in your trial judge, that emotion in lemonade to exclude any argument. And that's clearly, disingenuous. And I had that exact thing happen in a case. The judge, the officer wrote down in the statement that the defendant said, I'm, I know, or I'm not really a gang member, but I know a lot of gang members, something like that. And then they tried to argue that he said, "Well, I'm not really a gang member." And the judge said, "Well, there's not a comma there. There's a period." Like, if that's what you're trying to say, I mean, there's not a period there. It's one sentence. It's not like, clearly what you wrote down is somebody saying, "No, I'm not really a gang member. It's just that I know a lot of gang members." And the judge wouldn't allow them to do it because he said that that's not a fair representation of what the evidence says. It's not a fair, reasonable inference from the argument. So, I mean, that should be something, if they're concerned about that you'll see at a motion in limine, to exclude them from trying to make such a, ridiculous argument. But, um, you know, he's absolutely right that that's definitely an argument that I could see them trying to make.
Yeah, me too. I mean, I'm sure they will. Like, why wouldn't they? Um,
Right, because the
let's
truth,
see.
the
Bill here
search for
says not
truth is
aware
what we're
there
doing
was
it.
a 14-day rule on questioning after Miranda is invoked. I assume RA invoked on the 13th, so they shouldn't have re-questioned until after 14 days, but I could be wrong.
So I didn't see
Um,
anything in Indiana that suggested there is a hard and fast day rule. That doesn't mean it doesn't exist. I was doing research while I'm sitting here. Um, it sounds to me like most of the circuits follow, there is no, hard and fast day rule. But, I there could be something that I didn't see.
yeah. Um, yeah, I'm just like I'm ready for this thing to go to trial. Like I'm just beyond it. It's like I'm just like I'm ready, but I'm like terrified that like the defense just like it's such a short period of time to get ready, and they got a lot of things that they're trying to do. They're like kind of. I mean, it seems to me that Rosie's trying to handle the confessions, like that, like he wrote that motion up. So he's dealing with the confessions, and you got like Baldwin, Andy seems to be the one kind of like focusing on the Saudi thing, like I don't know. It's like strange because you got two attorneys in different offices. I'm assuming that they're war rooming at the same office during the day, but I mean, you never know. And it takes time to write these things up. I mean, you could tell Baldwin rushes through these motions and, is just trying to get it down on paper and just filing them without proofing them, because they're replete with little errors and stuff like that. But I mean, that's what happens when you have no time to do anything, but I think the fear of Alan making it a year, 2 more years before this thing goes to trial where, you have all the time that you feel that you need to really be prepared in every single way, is at a risk that they're willing to take, and I just don't think it is, like I'm not getting any sense that these guys are going to be seeking continuance to not go when this thing is set to go, like I'm not getting that sense at all. It's like the closer you get to trial, we've done it. We've been there. We're 2 weeks out. We're like, oh my God, we haven't filed a motion to continue, and then we're going in and just taking the beating from the judge that we should have filed this like a month earlier, and it's like you just got to take the beatings. So all right, I think that'll wrap it for this one. So if you're one of those people that hates when we thank people, drop off because it's that time.
And
We're gonna
anyone who
go
wants to
through
go
it.
to bed,
Yeah,
I
me.
don't go to bed this early. I'm gonna get off this and work anyway. But so I hate someone to be like that. Allison, always trying to get Bob off.
No, you're good, babe. All right, so you can jump off. I'll do the thank yous.
No, I'm fine.
Oh, okay. Dr.
Actually,
Vonda, new member. Like you've been a member, you're a long time and we adore you. Thank you so much. family hugs for you. Aw, family hug. We already went through Mia Bito. Thank you for that
Thank
$10.
you.
$10 holla, appreciate it. $20 holla. Here's for all your hard work. Thank you for all you do. Thank you so much for your support. We appreciate it. Always give her Dawn Burke 20 glorious DD memberships. Thank you so much for that generosity. We appreciate it. 20 family hugs going out.
Nice.
Wow, that's a big one. $50. Thank you, Bob and Allie. I always look forward to your streams. Thank you so much for your incredible support. How would you pronounce that? Is that an I or an L?
Which? Glenn F.
It's Glenn, right? Glenn F. The lips are throwing me off. They look like female lips. So I was like, is
So
that
what? You can't say anything
me?
about
I
anyone's
know, I
name
know, I know.
this
I
day and
wasn't
age.
liking
No, I'm not saying
I
you're
get
actually saying anything. I meant you can't tell anything in
right.
this day and age from
That's
any of
true.
that.
That's true. Well, whatever the case may be, thank you for that $50 hollow. Appreciate it so much. Nav the EO again, the hero. God, I want to find out who Nav the EO is. Thank you so much. And I'm sure all the members that were gifted those 50 memberships are very grateful. Thank you so much for your continued support, Nav. Nature Lover 82, $4.99. I'd love to be a fly on the wall when you two argue a case. No, you wouldn't. I'd absolutely love it. You two are amazing. Thank you. Thank you. Thank you for the compliment. We appreciate it. Stacy, member for 3 months, arresting bridge guy. Would you get a written waiver?
You would think
You would think.
so. I
You would
mean, like,
think.
that's the kind of shit that makes you think, look, it you know, yes, we are defense attorneys, but I'm going to tell you it's by no coincidence that they asked Richard Allen to come in instead of picked him up. That they are at least reporting that they asked him, "Yo, you remember your warnings." They know the law. They know what they need to say to get there, and I told him that he was free to leave. It's sort of like everyone who gets pulled over for a DUI, everyone has red eyes, slurred speech, and the smell
Strong
of
smell of alcohol.
alcohol
Yeah.
emanating from their mouth.
Right.
Everyone. And the
They're
same
trained
thing
to
with
write reports.
otherwise, I've got no reason. I smelled the scent of marijuana. Oh, and now I smelled the burnt scent
Burnt scent.
because,
Burnt marijuana
now
is the
now marijuana is
PT.
legal to have in your vehicle as long as it's, sealed and in its proper whatever. So it's burnt marijuana.
Right. Now that's their probable cause.
Yep. Did you
$2
find it?
hollow.
No. Did you find a lighter?
But I
No.
smelt it.
What?
I smelt it. I
Yep.
smelt it. Thank you for that $2 holla, QB Designs. Appreciate it. Member for 1 month. Kraken Studio, the real booty. No
Real
one cares
booty.
until they have an injustice. Hashtag defense. True that.
It's true.
No one cares until somebody in their family's arrested. Then they care. Then they care. Appreciate your support. Aw, family hug. $5 holla for someone who used to live in Delphi. Can truly tell you the corruption there runs deep, especially with bribes. Thanks, Nav the EO, for the gift.
And,
Love you
like,
guys.
that's kinda
Appreciate
what the state's trying to do by, like, showing not the state, the defense, by kinda pointing to every instance of what they see as misconduct or wrongdoing or,
it. Right.
to be like, "Hey, this is happening. It's happening in all these other ways, so why in the hell don't you think it's happening here?"
Right. But
But
like
thanks
the
again,
judge
nature,
Gull,
love
yeah,
80.
thank you, Nature Love 82. It's like Gull hates them. Like she's just not like and I don't know if she like personally hates them or she just professionally hates them. Like we've had judges that can't stand us. So there are just judges that you rub the wrong way as a defense attorney, and you don't ever cure that, and in this case, Gull's never going to have the warm and fuzzies about Brad and Andy. That's just facts. It's never going to happen. And, like I think people have stopped
Well, they're not
asking if
doing
she's still
themselves any favors by putting together, proposed orders that have the judge indicating, you know, that the evidence suggests that Richard Allen is innocent and that, you know, but at this point, I don't think it makes any difference. Like, they're going to have to deal with
yeah,
a judge who's going to make the rulings. This is going to be all about the jury very soon. And this judge is going to make the same pretrial rulings no matter what they do at this point.
Right. I mean, it's like it is what it is, you know. So it's like we'll just go through the process. We'll get it in front of a jury, and we'll see where it goes. $2 holler from Dusty. Appreciate you. Thank you so much. QB Designs, $5 holla, and that's the last one. Appreciate your support, QB. We love that. All right, y'all. It's been fun. It's been a long day. If y'all are at all interested in the Daybell thing, make sure you're with Jay and I tomorrow. We'll be streaming it again.
Or also listen to our Lori Daybell coverage. It would be a real good
It's great.
companion
It's great. It's great
piece.
coverage. It is. And it's like it gives you the primers of what's to come. Maybe it's a different case. There's, the difference in Chad Daybell and Lori Daybell is that John Pryor, who is going to irritate everybody, everyone's going to hate him because he's trying the case. He's making proper objections. He's trying it. He's putting on a defense. I mean, it's a different case. It's a vastly different case than Lori's, where her lawyers just kind of sat there and were like, whatever.
Just in case you wanted to know. And I
Not
don't think she
crossing
needed to tell
anybody.
you. But Glenn F is a woman.
Yeah. All right. Good. See. All right. Thanks,
I
Glenn.
was
She
looking
did
for any
not.
questions from like our members and like to see,
Yeah.
before we hopped off, if I could answer it. And I just happened to see that. So I put it up there.
All right, y'all. So thank you all for being here with us. We appreciate you. Even those of you who are trolling and hate us, we appreciate you too. It's hopefully someday we'll say something that kind of like gets through to you. And maybe we'll say something that makes sense. You never know. You never know. But we're going to keep saying it. No one's ever going to stop us from saying it. So
That's for
you can
sure.
take great comfort in that fact that will be a consistent pain in your ass preaching about the Constitution and our rights as citizens in this country. So we're not going anywhere. Sorry. All right. Thank you guys. Thank you, mods, for all your hard work. We love
Yes,
you.
thank you.
Love you so much. You guys are amazing. Thank you for Mandy for putting together a great thumbnail and, of course, modding and basically doing everything. Mandy and Dizzy are two superheroes behind the scenes who always deserve specific shout outs but all of you mods are wonderful. I adore all of you guys. And make sure get us in the algorithm. Like it, share it, subscribe.
Have to minimize the comments and you'll see the thumbs up.
Yeah. And if you really dig it, think about becoming a member. Thanks to Nav DEO. Nav DEO, we always have a constant influx of new members because Nav is always super, super gracious. And so is Don Burke. Don Burke is always between the two of them.
There's a lot of people who often are.
There are a ton of people, always givers, we call them, and we love you guys. All right. So thank you all, because without you, I'd just be an old man.
Talking about a lot of cases.
Boop. Talk at you next time.